Thank you for watching News Echoes of the SSM Schengen Media. And where else will you be today if not with us? My name is Shegun Johnson. Today is the day Nigeria is made or broken. Well, you know what I mean. Make or break is today for Nigeria. As the Presidential Panel Tribunal, they look at who has won the February 25th, 2023 election. 3 political parties are challenging APC, Tinubu, and INEC. We'll be going live in a moment, but I have my colleagues in the studio with me. I have all the way from Toronto, Canada, Sir George. Sir George, welcome to this special program.
Good morning, Dr. Johnson, and good morning, just viewers from around the world. We want to welcome you to our show today. Like Dr. Johnson said, today is to make or to break, and we're here to listen.
Yes, sir. Yes, sir. And from Milan, we have Mark. Mark, you're welcome to the program. We need to hear you, Mark.
Good morning, Dr. Shegun. Good morning, Sir George. Good morning, viewers. The viewers are really out there now to know what's going on. It's good to be with you guys on this very special day, the 6th of September,
2023. And before we go live, let's try and quickly survey. Do we know what is going on in Nigeria, in the cities? Are there soldiers? Are there policemen all over the place? There have been some discussions before now. People like Odili and some others have been saying, whatever the outcome, everybody should just be calm. Well, many Nigerians are waiting for justice, not just peace. There's a difference between peace and justice. Justice brings about permanent peace. Suppression is when you are having injustice and you can't talk. It's an African adage says that you cannot slap a child and tell him not to cry. Now, Sir George, what are the feelings you're having about today concerning everything going on?
You know, as a child of God, as a Christian, I read in the book of Jonah, when Jonah went to Nineveh to pass judgment, and God told him to go there, but he decided to go the opposite way. The fish swallowed him and brought him back into vomited him at the shores of Nineveh. So now all of a sudden he was under the oak tree. The sun was scorching, but he was watching to see whether, because he knew how lovely and how loving God was. He just was watching to see if God will bring punishment to these people. But evidently, God dealt with him. You know, in the book of Isaiah, chapter 5, verse 20, says that, woe unto them that call good bad, bad good, call darkness light, and light darkness. This is what we're seeing in Nigeria today. You know, somebody just put something on the forum and said, both sides, the defendants and the prosecution, everybody, they know the truth. Today is not the day to judge whether there is so. The judges are under judgment today, because I'll tell you what is going. If they miss it this time, the axe is on the root of the tree, because it will make or break our country. Today, that's it. Today.
Okay. While I'm welcoming Bidi from Lagos, you're welcome to the program.
Thank you, Dr. Shegun. Good morning, everyone in the studio, our viewers all around the world. Thanks for joining us again today. Let's do it like always.
Massive Mark, what are your feelings concerning
look at this guy? His name is Justice. Samuel Justice Obi says Nigerians are waiting and in anticipation for the outcome. That middle name Justice there is what we're waiting for today.
Mark, can we hear your immediate impression before we go live?
Yes, immediate impression is the curiosity, the anxiety is high. Everybody is glued on to today's event. Millions of Nigerians around the world, international observers are on guard, and we're all waiting for this judgment today. The Presidential Election Petition Court will be giving its verdict. What we know, like George said, is it's obvious. I mean, it's out there. But the interesting thing is, Dr. Shegun, the other party, PDP, thinks today will be to their own favor. You know, they are the one actually trying to say today is their day, because the INEC results made them have, they were number 2 on the list. So they are out there. You can see their lawyers, you can see the council, and they feel today is their day. But the LP, Labour Party followers and lawyers and everybody is on the side of Labour having today as their day. So it's a mixed reaction, Dr. Shegun. And at the end of it, anyway, we want to see eventually something, judgment done on this Nigerian election 2023. So this is what is happening. The anxiety is high and everybody's really, really anxious today.
Okay, thank you very much, Mark. Bidi, do you have policemen all over the streets in Lagos? How is the security ready for today?
Dr. Shegun, what do you expect? We have security men and women everywhere in the strategic places in Lagos, more especially in Nigeria, more especially in Abuja, trying to silence Nigerians. Asari Dokubo has stormed Abuja with his security people, the DSS, the police, they are all in Abuja trying to stop Nigerians. They've already, before now, they've already given out warning that no one should protest. Do you understand? The judge, Justice Odili, first came out to gaslight on the situation of today. They've already told us what we should expect. Not only telling us, like Sir George said, not only telling us what we should expect, they've already told us what is expected of us. Don't talk, don't do anything, don't protest. The DSS has come out to warn Nigerians. If they see you on the streets, they will pick you up. Nigerian police has come out to warn Nigerians. Now, Asari Dokubo, the same thing. You see, why I'm calling on ECOWAS and AU, who are quick to sanction states and countries. They are looking at what is happening in Nigeria. The DSS have warned Nigerians not to protest, not to do anything, not to go to the streets. The Nigerian police force has done the same. But Asari Dokubo, with a lot of buses, has stopped Abuja street with his boys, trying to stop any Nigerian that will come to protest against whatever judgment that they don't like. We're not talking about favor here. They don't like. Nigerians will not go to street, but the nonchalance, the touts are allowed to go to the streets because they belong to President Tinubu and Asari Dokubo. I don't understand what is happening in this country, but we are just watching because they've already told us what we should expect. Now, they're telling us what we should expect. They are not telling us not to speak. You can't possibly beat a child and tell the child not to cry. And ECOWAS and AU are watching this. And they will not interfere or do anything. In fact, Tashegu, I am in tears for this country. I don't even know what to say again.
Okay, let me ask you a few questions. Are the banks operating today, the commercial banks?
Yeah, but they're operating, but their operation is sketchy.
Because they said there will be no banks today. Do you think some markets will open today if they are wise?
Yeah, even the Lagos State has even told some markets not to open. Some people will open, some people will not open. Some people will not open.
This is democracy.
There's a big tense in Nigeria. Nigeria is tense now. Nigeria is tense. And what Nigerians are doing, trying to, comfort themselves, is to just take themselves out of what is happening here today. Because they've already told us what we should expect. They've already told us what we should expect.
Okay, thank you very much. We'll soon go live now. One of our viewers, David Nwuji, said, remove emotions and report what is happening. If you like, go and protest. Another one says, today marks a pivotal moment in Nigeria's history as the tribunal election takes center stage. Please keep on bringing your views and we will read them. We want all sides of the story. We're not going to be one way. Democracy will be put to test again today in Africa, Emmanuel Ofoa. Samuel Justice will be like George read out. Nigerians are waiting in anticipation for the outcome. Keep writing us, and we will be reading out your views. We will read all sides of the story. We are not partisan, and whatever is the case, we will report. Before we go live, I hope the report is not started reading. Milan.
Well, it's still the court,
They are
so
still
much
presenting themselves.
yes,
Protocols.
those
Okay, while they are still on
protocols.
protocol, let's continue, please. Once the judge starts bringing their judgment, Sir George, today, not today, as they say, and we must not pretend it will make or mar Nigeria. Don't let us pretend. The African Union, like BD said, is fast making itself irrelevant because they cannot differentiate between democracy and dishonesty. When dishonesty is going on in Ivory Coast, Ouattara coming on a third term, Yadema coming on a third term, they keep quiet. They are nowhere to be found. But when coup comes, they expel them from the AU. Sir George, African Union is not for the people; it's for the government, isn't it?
Well, you see, you have a gang of people that want to make rules and regulations to protect themselves. Nobody's thinking about the common man. Nobody's talking about the welfare of the people that are being supposed to be ruled. So this is one of the major problems that we have, and the funniest part of it is that the more decisions they make, the more foolish they look. But they have no shame. They have no shame. Think about it. Because how can you see something that is glaring you right in the face and you know that all of us with our consciences, we can understand and we can judge, and yet you turn around and call black white and white black, good, bad, bad, good. What kind of, what world are we living in? Because right now, it's all come right there to showcase the stupidity of these people call themselves AU. And how foolish they are. It's very, very unfortunate. But you gotta call a spade a spade. Because we have mastered fakery. We have mastered fakery. We know how to coin words and make it don't say what it's supposed to say. We give it fancy names and all kinds of things. There is no democracy in Africa. He said, what we see, one time I was trying to find the words to, oligarchy and kakistocracy join together. You get these people that come together, they put themselves together, incapable of ruling, and yet they place themselves, recycle that government among themselves, and everybody's glaring and looking at them. But you know what? We were never created to be suppressed. God never created mankind to be suppressed, because suppression can only last for so long until that divine gift that was given, enough is enough, comes, the whole place will explode. They better be careful, because I can guarantee you, if they're not careful, most of these people will pack their bags and run away from Nigeria if they are not careful.
Yeah. Their family are out of the place already. Well, one of our viewers, Okari Shaba, has said, in this atmosphere of uncertainty, one thing is clear: the Nigerian people yearn for justice in peace. The people believe that the judiciary would fail Nigeria again after 1960. Today is another deciding day in her history. Well, Mark, have we lost faith in the judiciary?
Today will determine that, Dr. Shagun. After today, we will know if our judiciary is really judicious, if they are really just, and if they uphold.
Today.
So we can't conclude now. Let's see how, if the woman, the justice woman is truly blind, if of a truth mankind can be as just as God wants us to be. So today is that day.
Massive Mark.
Yes.
Massive Mark, you don't know that woman. You don't know Justice Mary Odele. She's not lying. They brought her to gaslight Nigerians. They brought her, she did that in River State. When her husband has to wedding and rescue her, that woman does not have any atom of womanhood in her. Because what makes you a woman? You have this attribute of nurturing, creating, and protecting. But that Justice Audrey does not have any atom of those attributes in her as a mother. Because first, she is a woman. She became a mother before she became a justice. She doesn't have all those things. That woman, Nigerian posterity will never forgive her. We are watching. They've already completed their plan.
I think she belongs to the ruling class, and she was defending her class. Yes. The ruling class is a very minority class in Nigeria, where maybe 0.11 of the. So she was defending her ruling class, but I think the woman Mark was also referring to is the judicial woman. But
yes,
Didi, I want to ask.
Yes, I want to say that what I meant by the woman is the symbol of justice. The symbol of justice is a woman that is blind.
That they normally blindfold her, and then she will bring the sword.
Yes. So I'm saying that we hope today that symbol will really represent, because if
somebody said that a blindfold has been caught in the middle in Nigeria, so the person is trying to, is blindfold. Well, Bidi, I'm ready to ask from you, what is the palpitation in Lagos? Lagos used to be the place of Asiwaju, but the February 25 election has obviously shown us that Asiwaju has lost his favor from Lagos. I mean, the voters say so, not me. And he came a very distant second to Peter Obi. So what's the palpitation? Because we saw that only yesterday was the Blu-ray line started working when the judgment is about to come today. Is there any correlation is that, so that we can say, leave them, APC is working, look at this rail. But what's the palpitation? Are they expecting anything, or it's just life as usual?
And Dr. Shagun, there's something you will understand. In Nigeria, Lagos is called the center of excellency. Lagos is not called the center of excellency for just anything. If there is going to be any revolution, any protest, first it starts from Lagos. Lagos looks like the peak of any revolution, anything that will take up in Lagos. Now, after 25th February election, and the Lagos boy lost, what Lagos state government have resorted to is using intimidation in Nigerians in Lagos. They've used intimidation, they've used fear, they've used humiliation to weaken Lagos people, not to talk, not to speak. Even today, there are places where Lagosians are positioning themselves for protest, but Lagos state government has warned them. And you know how Lagos state does it? They will come after your source of income. They will come after your business. They will come after your person. So it's weakening people from speaking up. It's weakening people from coming out to say things. Look, let me tell you, there's nothing, I can't say. What is the work that APC is doing in Lagos? Is it the work that they came with lies? You remember when they launched this rail line during President Buhari regime?
Yes.
They launched it. Now, the one they have even commissioned was from Siemens to my 2. This blue line, what the uniqueness of this blue line is that it's supposed to come from Siemens to Okoko to Seme. That is the unique nature of this. That was what gave this blue rain the uniqueness. But what they commissioned is just a little fragment of what has been projected. So I don't see.
And if you know, they have spent 10 times the amount of money budgeted for it, 10 times. And there are times that, and today Lagos State is the greatest debt state in Nigeria. Nobody knows that one, and I'm giving that as an insider. Lagos State owes more than any other state.
People know, but they wouldn't want you to speak about it. If you're speaking about it, let me tell you, they know. When last 2019, when Babatunde Badamasi, EU governorship president, was contesting on that platform, he brought every of those things to the bear. And what did they do? They went after him and went after his source of income. So that's the way they do in Lagos State. They will come after you. Lagosians know, but nobody will speak about it.
They will soon meet their match. But let's go to Abuja and hear what is going on in the court. Well, let's have Abuja for 5 minutes, and then if they are still on protocols, we'll return to discuss. Abuja.
The Nigerian youth has sponsored the Abuja streets. They're everywhere. They say they won't kill all of them at the same time. But some people still are afraid. They are home. Charlie Boy is leading some of the fraction. They are on the streets. They are on the court there. Yeah.
Okay.
They are there.
Even Milan, can we have what is going on in the court?
I think admin is having some technical issue.
But we have we had some discussion before now, and we were in Abuja before we started, and we had them clearly. But you might be right. Maybe we are having some. So tell us what is going on in Abuja. You said Charlie Boy is leading.
Yeah, Charlie Boy is leading some sets of group. They are there. They even started since 6:30 a.m. this morning. They are asking people to come out.
The government is not out. What are they protesting about?
No, they are not protesting. They want to watch this. They said they want to watch the judges in their face as they lie to them. That's what they said. That they want
where are they in a square? Are they in a square or what?
No, they are around the courts. You know, they will not allow them to come inside. They are around the court facilities.
That is dangerous. George, that is dangerous because one person, it could even be a government man that will spark something, and then the government will move in and shoot and maim.
That's the issue there. One thing is that to a degree, I think that civility is one thing that is needed today. And if there is supposed to be any type of
reaction,
it's supposed to be planned, delayed reaction. But you know, I'm sensing that because of our disappointments over the judicial system in Nigeria, it's almost like we're expecting bad news. You know, this is the tone that I'm receiving. You know,
George, it's better to have low expectation, so that you won't be disappointed.
Well, you know, the thing is, I'm remaining neutral to this point, expecting that you know, some kind of way there would be a release of information that will speak volume to truth and justice, fairness, and equity. That's where I am. So for now, but Massive Mark, can you get us involved in Abuja? Can you put us in Abuja if you can hear me?
Dr. Shego, I want to respond to what you said. You said You said that is dangerous. That one politician might spark and they will shoot them. Now, my point,
Yes.
the problem we have in Nigeria is that so many of us are so comfortable with our situation, our environment, that this country is messing up and messing us up. The people that gave us this country, if they were this afraid, I don't think we will have a country to call Nigeria today. I'm telling you. And because the Nigerian politicians, our leaders, they know that we are afraid. We love life too much, that we cannot fight. Because let me tell you, do you know what I've realized in Nigeria? You see, Nigerian government getting better. We don't need intellectual revolution. Because the people we are dealing with, we've tried it. The people we are dealing with don't have respect for intellectual. They don't have respect for intelligentsia. So you can't fight them with it. But the only way we can fight this war is God. It's physical. I'm telling you.
Yeah, but you see what we are experiencing in Francophone Africa these days, the coups, I mean, they're not revolutionary from the people. They were masterminded by the army. And so Nigerians too, they don't like what is going on, but they are waiting for a naked power like the army to be in charge. In Nigeria, that is not happening because the generals are overfed.
Exactly. They can't. Before, the generals, they used to give them little. They used to give them small. But this time around, they are the sharer. Lately now, you remember they just gave some generals some oil well. Now, when you have oil well to you and your generation, why would you distort the government? They used to give them, they used to dash them little. Now they are part of the system. So they are okay. Do you understand? So if we are waiting for our generals...
Can you imagine Buratai, who bought 2 houses the same time at $1.5 million in Dubai and said it was part of his salary, and he couldn't prove all his salaries put together from the beginning to the very end of his career will never be up to $1.5 million, which means he never touched the money. But then he left that place and was made an ambassador in the Republic of Benin. That's the kind of general we're talking about, among other things. So we know. But Sir George, just a day before the judgment yesterday, according to the Guardian of Nigeria, it says subsidy returns as federal government leverages NNPC to manage market shocks. So federal government has gone to subsidize oil again to manage market shock a day before judgment. The Blue Rail Line worked a day before judgment. Orderly spoke days before. Now, why should anybody return to subsidy in Nigeria at a time like this?
Well, you have to ask yourself the question: if people are trying to give you answers when they don't know what the questions are, what would you expect to be getting? We have seen a lot of decisions being made irrationally without any preparation whatsoever. The discoloration of our naira, the subsidy removal, and everything that was done, nothing was strategized, nothing was planned, no contingency plan of any type. You just blob it out there and let whatever take you wherever it's taking you. So, and this is exactly what we're talking about. When we're talking about, government, we're expecting that people are people that will think before they act, rather than reacting emotionally. Like somebody was just saying, let's not, somebody mentioned this thing, or say, let's not become emotional, report what is going on. Yeah, I know, maybe Adam, I'm not quite sure who you're talking about. But if you're not emotional in this particular situation in Nigeria, then maybe you're dumb, deaf, and blind. Because a lot of people that are out, no, I'm so sorry. Because the point, you can control your own emotions, yes. Now, but when you start dealing with people in the lower class, people that are dying daily, people that are even suffering from, malnutrition because of lack of, the economy is in shambles. Everything is there. It will make you want to cry. Maybe you're comfortable where you're sitting at home. Maybe you got a good job, or maybe you're not even in Nigeria. So you can talk like that. And when you deal with certain group of people, my brother, if you're not emotional, then your heart is a stone. So, but anyway, not to go into that type of situation. Yeah, we are in the media. We need to be rational in our, what we do and how we do it. So, my personal thing is, I'm waiting. I'm not expecting good or bad. I'm in the middle, waiting for whatever they prepared to be delivered to us, and then we will respond appropriately after that. I'm not calling anybody.
I have two issues here. In the United States of America, only yesterday, the leader of the Proud Boys, one gang of people who supported Trump, especially to invade Capitol Hill, he was jailed for 22 years by the judiciary for masterminding it. He wasn't even at the Capitol Hill. He masterminded it from behind, and he was jailed 22 years. Other members of his gang have been jailed 10 years, 15 years, and the rest. He was jailed 22 years. The judiciary taking care of Trump's men accordingly. Nobody is saying the judiciary is partial. Even Joe Biden has no power over the judiciary. And because of bringing down the strictness of democracy in their country, they are dealing with them. BD, I see in Nigeria, like you informed us, I never knew that Dokubo has taken his men to Abuja. But now, I'm told that where the state actors, that is the police, the soldiers, they are no longer effective, then the non-state actors are brought into power. For example, Government Tompolo was the one monitoring our oil business in Delta region because the government has failed. Government parastatals have failed. Now, so Dokubo Asari is correct in saying that the Nigerian army, the police, they are useless because he's going to take over. Does it mean that we have birthed a new Wagner group in Nigeria?
Oh, of course, that is what it looks like, or that is what it is. You know why they will tell you that the government has failed? It's because they are not real. It's because they are not following the law. That is why, because their intention, whatever they are doing, their intention is not clear. It's not for the people. It's for their own personal interest. So they need a group that will project that their personal interest. Exactly what the past government did by appointing Tombolo to be the one that will monitor the oil pipelines in the south. Now, President Tinubu has brought Asari Dokubo to come and bring his boys to fight Nigerians. Nigeria. This is the second time this is happening. You will say people should not protest, but Asari Dokubo will bring his boys and they protest and they will be allowed. And like Sir George said, we'll still have the judiciary. We'll have the problem in Nigeria is that no one is even talking. I remember when I was small, I used to hear a lot about freedom fighters, activists. Today, we don't even have any activists in Nigeria. Because of what? Because of this same APC government. It started with Buhari government. They've silenced them. Many of our activists are on payroll of APC governments. Many of our freedom fighters are on payroll of this APC government. And what do? They silence them. They send them money for doing nothing. Now, what would you do? Why would you challenge a government that is feeding you? You can't. And that is why
also is the first place in the whole world I see governments without official opposition taking its rightful place in giving alternative policies. Yeah, we are going to Abuja right now, and we will be back. I believe that we are getting to Abuja. The court the tribunal that is giving the verdict will be back. And I think David Nwuju will be very happy because he just wrote, Sir George, the fact you are here to report what is going on means you should keep emotions apart. That's what Sir George said. He said this is the day we should keep emotions away. We should be serene on a day like this. So, David, yes.
It is tried law that abuse of court or judicial process simply means the use of a court process malafide or in bad faith to the annoyance of the opponent. One variety of it is the institution of multifarious actions between the same parties with regard to the same subject matter and same issue in the same or another court. A quick look at the originating summons in suit number FHC ABJCS 1275-2022 will show that same was instituted in the Federal High Court, Abuja, on 27th day of July 2022. Being a pre-election matter, it ought to have been determined within 180 days, as required by Section 285, subsection 10 of the 1999 Constitution. It therefore means that it lapsed by January 2023, about a month the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also strong tenants. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in Appeal number CA/ABJ/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by either party again in the same or subsequent proceedings, except in special circumstances. For issue estoppel to apply, the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in both proceedings. B, the decision which creates the estoppel must be final, and the parties to the judicial decision or their previous to the proceedings in which the estoppel is raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually in issue in the proceeding. See the cases of Oyekola and others versus Amodu, OSPM Limited versus Nibel Company Nigeria Limited, and Dasuki Retired versus Federal Power Nigeria, Sanitation Supply. I've studied the case sought to be relied on as estoppel in this case. It is apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standing by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discountenanced. On whether the question is statute barred, I had held in the earlier motion filed by the first respondent on 7th May 2023 and for the respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination or sponsorship of the first respondent, is a pre-election matter. That being a pre-election matter, it ought to have been instituted and ventilated by the petitioner before the Federal High Court within 14 days from the date of recurrence of the event or action complaint of. That not having been done, the course of action in this petition stands barred by virtue of Section 2859 of the 1919 Constitution of the Federal Republic of Nigeria as amended. On the issue of local standing, I had also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidate by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party for an election. Such process of challenging the nomination is sanctioned by Section 84, subsection 14 of the Electoral Act 22 and 285, Section 14 of the Constitution. Tishin Kafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. It therefore follows that the course of action in this petition, which is rooted in the nomination or sponsor of the further respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the further respondent by the second respondent. Thus, in People's Democratic Party (PDP), an Independent National Electoral Commission and others, unreported decision of the Supreme Court, delivered on 26th day of May 2023 in SC/CV/501/2023. I heard the matter has been reported, but I have not been able to avail myself of the report. The Supreme Court held at page 71 page 31 lines 1 to 16 thereof as follows. Court, the provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the actions or inactions of rival political parties under the guise of challenging the decision or activities of INEC. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party, no matter how pained or disgruntled a political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidates for any position. It must keep mum and remain an onlooker, for it lacks the local standing to challenge such nomination in court, close of court. It is clear, therefore, that a political party such as the petitioner herein only has the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. For that reason, it is my view that the course of action in this petition being on the nomination and sponsorship of the third and fourth respondents by the second respondent applicant, the petition is incompetent for lack of local standing on the petition to institute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer is that Section 133, subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred us to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, subsection 1 of the Electoral Act stipulates, I quote, an election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word or, it means that an election petition may be filed by the candidate alone, or the political party alone, or both of them. The objection on this ground is also discontinued. By another motion filed on the 15th of May 2023, the fifth respondent, Das Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of this court dismissing this petition in its entirety for want of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders at this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. I've also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral Defense persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This is Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis. As sui generis, and its procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not necessary parties in an election petition. See the cases of Agbere and Mimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Gaidam. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondents. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid. Close of court. Indeed, a holistic reading of the facts of this petition does not disclose complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. In other words, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Finally, I order that the name of the fifth respondent is struck out of this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So after the pre-hearing session, hearing on the petition opened and closed on the 21st of June 2023, the petitioner called one witness and closed his case. None of the respondents called any witness, but tendered some documents from the bar, and the petition was adjourned for adoption of written addresses. Parties then filed and served written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1, whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging the qualification and return of the third respondent as the winner of the presidential election 25th February 2023. 2, whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134, subsection 3 of the Electoral Act 2022, can the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent be validly raised as a ground before this honorable court to question or challenge the qualification and return of the third respondent as the winner of the presidential election of 25th February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 25th February 2023. Or whether considering the relief sought as per the petition accrues no utilitarian benefit to the petitioner, petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been reduced in this judgment, including the issues raised by the petitioner. Now, it is apparent from the averments in the petition, the oral and documentary evidence, and the submissions of counsel that this petition is grounded on the disqualification of the third respondent to have contested the presidential election of 25th February 2023. This is evident in paragraph 15 of the petition, wherein the petitioner pleaded thus. I had read it earlier. This is further explained as emanating from the non-qualification of the first respondent to have contested the election as the vice president candidate of the second respondent. It is specifically pleaded in paragraph 17 of the petition as follows. Your petitioner states that the fourth respondent was not qualified to jointly contest with the third respondent for the presidential election held on 25th February 2023, having been purportedly nominated by the second respondent as its candidate for more than one office. The specific reasons for questioning the qualification of the third respondent have been pleaded in paragraphs 16.1 and 2 of the petition as follows. Those paragraphs have been reproduced. If you get the judgment, you will see it there. So a combined reading of paragraphs 15, 16, and 17 of the petition, coupled with the particulars thereof, show clearly that the petition is premised on non-qualification of the fourth respondent. I find it necessary to state that the grounds for questioning the return at an election are stipulated in section 135, subsection 1 of the Electoral Act, that has been reproduced earlier. For the purpose of this petition, it is the ground stipulated in section 134(1)A that is relevant. In other words, the election of the third and fourth respondent as president and vice president is questioned on the ground that they are not qualified to have contested the said presidential election. I've considered paragraphs 18, 19, 20, 21, 22, 23, 24, 26, and 28 of the petition as relevant for determination of the petition, which paragraphs have been reproduced in this judgment. In response, the first respondent, that's INEC, filed a reply to the petition where it was averred in paragraphs 14, 15, and 16 of the first respondent reply to the petition as follows, which have also been reproduced. Second respondent also filed a second respondent reply to the petition, and also made their own averments in paragraph 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 25, 29, which have been produced herein. So from the totality of the pleadings in the petition and the replies of the respondents, What appears from the complaint of the petitioner is that the fourth respondent, while still a candidate of the second respondent for Borno's Central Senatorial District, was nominated and did accept to be the vice president candidate of the second respondent. That this act violated the provision of Section 35 of the Electoral Act 2022 as it amounted to his double nomination. That in the circumstances, his nomination as an associate of the second respondent for the present election is void. That the result is that the third respondent was disqualified from contesting the election because he did not have a validly nominated running mate at the time of the election. The petitioner relied on Section 131 and 142(1) of the 1999 Constitution for his postulation. Section 131 and 142 sub 1 of the Constitution of Federal Republic of Nigeria as amended stipulate as follows. A person shall be qualified for election to the office of president if A, he is a citizen of Nigeria by birth, B, he has attained the age of 40 years, C, he is a member of a political party and is sponsored by that political party, and D, he has been educated up to at least full certificate level or its equivalent. 142(1). In any election to which the foregoing provision of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running mate for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate is for election to the office of president who nominated him as such an associate is duly elected as president in accordance with the provisions aforesaid. The general principles of interpretation of the Constitution, which is the supreme law of the land, is that mere technical rules of interpretation of statutes are to some extent be avoided in a way as not to defeat the principles of government. That's why the words used are clear and unambiguous. A literal interpretation should be applied. In the interpretation, therefore, the provisions of the Constitution are to be accorded holistic interpretation so as to avoid ambiguity and arrive at the true intention of the legislature. The court must limit itself to the words used in the Constitution without resort to any external aid or materials. In the cases of Sani and President Federal Republic of Nigeria, Amadi and Ani, and Agi and PDP and others. Thus, in Wike Ezonwo Nwesom, Honorable Dr. Okuku, Adol, Peter Side, and others, the Supreme Court observed that the principle of conception of the Constitution to the effect that a Constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for the present, but for generations yet unborn. It was held that in construing the Constitution, undue regard must not be paid to merely technical rules, because in doing so, the objects of the provisions as well as intention of the framers of the Constitution will be frustrated. Courts have always been encouraged to adopt a broad and liberal spirit in interpreting the provisions of the Constitution while constantly bearing in mind the object which such provisions were made to serve, close of court. That being so, where the Constitution has stipulated the qualifications to be attained by a person contesting or seeking to contest for any elective office created by the Constitution, the courts cannot create or import into the Constitution any other qualifying or disqualifying factor. This has been the position of the Supreme Court and dutifully followed by this court. It has therefore been held that qualification or disqualification of candidates to contest election is exclusively determined within the context or scope of the Constitution, and that nothing can be added to it. In other words, the Constitution being the ground norm is superior to any other law, including the Electoral Act. Therefore, where the Constitution has qualified a person or candidate to contest an election, no other law except the Constitution itself can disqualify him. The petitioner, in this case, has premised his complaint of non-qualification or disqualification of the third and fourth respondents as the president and vice presidential candidates of the second respondent on the issue of invalid nomination of the fourth respondent. The fourth respondent, while still the senatorial candidate, of the second respondent for the Borno Central District allows himself to be nominated as the vice presidential candidate of the second respondent for the same election. Rulings earlier delivered on the motions and preliminary objections, we had ruled that the petition grounded solely on the issue of invalid nomination or improper nomination is not a cognizable ground of disqualification under the Constitution. In other words, the claim in the petition that the third respondent was not qualified to contest the presidential election because he nominated an associate whose nomination was invalid does not flow from any ground of disqualification of a candidate to the office of president as stipulated in section 131 and 137 of the 1999 Constitution. See the cases of Balewa and Muazu and Faleke and Anik, Tazu versus Yorea. And in Shinkafi versus Yari, the Supreme Court held that the Supreme Court has listed in section 182, section 182 very exhaustively all the issues that can qualify a person from contesting the office of governor of a state. From the record of this court, the facts have not disclosed any evidence to show that the first respondent was not qualified to contest elections into the office of governor of Zamfara State. It is my view that once a candidate sponsored by his political party has satisfied the provisions set out in section 177 of the Constitution and is not qualified under section 182 subsection 1 thereof, he is qualified to stand election to the office of governor of a state. No other law can qualify him. This authority can apply mutandis to section 131 and 137 of the Electoral Act. It has not been contended by the petitioner that either the third or fourth respondent is trammeled by the provisions of section 131 or 137 of the 1999 Constitution. The complaint of the petitioner rooted on nomination and sponsorship of third and fourth respondent will find accommodation in a pre-election dispute, which the petitioner cannot even pursue, not being a member of the second respondent. This section 84, subsection 14 of the Electoral Act 2022 and 285(14) of the Constitution. While I'm tempted to put an end to this petition at this stage, but realizing that this court is not the final court on the matter, I'm constrained to look at the merits of the petition. As pointed out earlier in the course of this judgment, a complaint of the petitioner in this petition is that the third respondent was at the time of the presidential election held on 25th February 2022 not qualified to contest the election. This is because, according to the petitioner, the fourth respondent was not qualified to run on a joint ticket with him, that is third respondent, as the fourth respondent nomination was invalid for double nomination, which violates section 55 of the Electoral Act 2022. As stated earlier, the petition contended that the fourth respondent was a candidate of the second respondent for the Borno Central District when the third respondent nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time the fourth respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent, who was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to ANIC as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to ANIC, that fifth respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents considered that the fourth respondent was ab initio a central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent via a letter dated the same date notified his political party that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified INEC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of its intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANIC, that in the circumstances, the said judgment of the Supreme Court constitutes estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions I had earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Osho Boja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was done by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, the candidate of APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. So, Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case. The other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributed judgment contains what is not in the lead judgment will not whittle down binding effect. Thus, in Olu Fiagba and others versus Abdurrahim, my Lord Fabi JSC said, of course, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements, edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now, it is apparent that the parties in Exhibit X1, PDP and ANIC and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or previous to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contramundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what that court has decided. See Black's Law Dictionary, 11th edition at page 1008, Demishola versus Bola Tinubu, Yanati Petrochemical Limited and EFCC, then Ladi Jobi and others versus Oguntayo and others, partition supply. It is no doubt that the judgment matter in PDP and INEC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contradictory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 election. He withdrew his candidature for the Senate before taking up the position of vice president candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, those of court. After considering those documents, His Lordship concluded at page 7 of the control judgment that, quote, it is clear, crystal clear.
Dr. Shogun, I think we're listening to live verdicts from Abuja. It's interesting how it's going out, even though the man reading is not audible enough. He's not pronouncing words very clear and audible. Dr. Shogun, what do you think? What do you say about this reading so far?
Well, so far, every petition that has been brought has been nullified, but we cannot conclude before their own conclusion. I find horrified that he dismissed Shetima's late application with a wave of hand, that is not going to use technicality against the spirit of the Constitution, whereas technicalities have been used in other cases. On this occasion, he said he's not going to disqualify it. So at least I picked that one among many other words. And like one of our viewers said, it says the countenance of the lawyer say it all. The claims in the petition are invalid. Same old. Let's see what next. Judiciary has failed the people again. Okare Shaba. Well, we've not reached the end of it all. So it's nullifying every petition one by one. And until we get to the very end, like we said at the beginning, whoever the loser is can still go to the Supreme Court. And yes, whether that will be judgment or not is another thing to be seen. But so far, he's been doing his job, and we will then be given a chance to analyze what we should make out of this. So he has not finished. We cannot conclude.
He has not finished. Thank you very much, Dr. Shogun. Other writers, viewers are saying, Bankole Joel says, all eyes still on the judiciary. And Okira Ashaba has been saying a lot. He said he's reading the same thing they read 4 years ago. So I think Okira has been following the Nigerian judicial system and how they run their things. But Dr. Shogun, it will be a very, at the end of the day, whatever happens here will be a very interesting one. Yetunde Junard says, I hope this judgment is fair. Nigerians are just suffering in silence. Yetunde, thank you. Thank you all. viewers, Dr. Shagun, we have actually lots of viewers on ground following us now. Let us say this is Schengen Story Media, and we are giving the live coverage of the Nigerian Presidential Election Petition. Today is the day to deliver the verdict, and we are following this event live from Abuja, the capital city of Nigeria. So, Dr. Shagun, what do you want to say again on this?
This is how we leave it. The Schengen Story Media will continue publishing it live. Don't go away. The publication will still be, but our European television stations will have to be off for now. But all our viewers, please continue listening. It may be, who knows how they will conclude. Mark, I can only hand it over to you.
Thank you very much. Thank you very much, Dr. Shagun. I know you have other activities to run to. But the live coverage goes on, and we'll be back on Friday to give some more insights and analysis on this. Thank you, Dr. Shagun.
God bless you.
All right, sir.
Simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nomination without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nomination. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, 4th edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the first respondent has not been established. In other words, both the mens rea and actus reus of the act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC highlighted this point in its one as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate at the election into the office of Senator representing Borno Central Senatorial District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent because the candidate of the third respondent had lapsed and was no longer in a position constitutionally to nominate a running mate. This contention of the petition is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 does not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this position held to be devoid of any merit. we'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as an elderly person, I know what is going on.
My Lord, we're just wondering, sir. We just wondering, my Lord, if the brethren agree with your judgment or not.
Pardon?
I said, we're just wondering.
No, it's a consolidated judgment. They will give their contributions after we have read all the judgments.
Oh, my Lord, yes. Please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my Lord. Thank you, sir.
All the court.
Well, so far.
The first part. Well, we can't tell at this time if it's the first.
60 to 79, 83, 98, and 99 of the petition for being vague, nebulous, and imprecise. After striking out those paragraphs, strike out grounds of petition alleging corrupt practices, failure of the second and third respondents to score majority of votes. 2. Strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition. 3. Strike out prayers 3, 5, Roman 1, and 2, paragraph 102 of the petition, as well as paragraphs prayers 1, Roman 3, 4, Roman 1, 2, and 3, and 4, in paragraph 102 of the petition, and thereafter dismiss the petition, eliminate being academic, being an abuse of. Second and third respondents' motion filed on the 13th of May 2023 stood for the following. 1. Order striking out paragraphs 9, 2, 5, 60, 66, 73, 75, 78, 92, 95, 96, and 97 of the petition, being vague, imprecise, generic. 2. Order striking out paragraphs 80 to 82, 84 to 98 for failure to disclose facts, support the ground that the second and third respondents did not score majority of lawful. 3. Order striking out paragraphs 80 to 82, 84 to 98 on the failure to score 25% of the FCT, which cannot be premised on the ground for failure to score majority of lawful. The fourth respondent, on the other hand, filed motion dated 8th of May 2023, seeking for the following. An order striking out this petition for being incompetent and in gross violation of paragraph 4, sub 1, sub D, sub 2, sub 7 of the first schedule to the Electoral Act 22. Order of this honorable court striking out grounds 2 of the petition and all associated facts contained in paragraphs 20, 2, 33 to 78 of the incompetent. 3. Order of this honorable court striking out paragraphs 2, 20, Roman 2, 33 to 78 of the petition for not being in support of any valid ground in the petition. 4. Order of this honorable court striking out paragraph 21 to 27, 29 to 100 of the petition for being non-specific, lacking in clarity, generic, nebulous, vague, speculative, and gold digging, in contravention of the first schedule to the Electoral Act. In the above applications, all the respondents relied on the provisions of paragraph 4, sub 1, sub D, and sub 2 of the first schedule to the Electoral Act, and variously argued that the paragraphs of the petition which they have listed are liable to be struck out for being vague, generic, imprecise, and nebulous. So arguing they relied on several cases which are cited here. By contrast, the petitioners have submitted that the respondents' objection in the listed paragraphs of the petition are not vague, nebulous, because the petition, the argument that the petition are vague, paragraphs of the petition are vague and nebulous is defeated because the petitioners have indicated in the petition that they shall be relying on spreadsheets and forensic/expert evidence to prove the avowed facts. Petitioners have particularly argued that in paragraph 61, 65, 67, 69, 70, 71, 72, 73, 83, and 100 of the petition, they have pleaded the said spreadsheets and forensic reports by incorporation or reference, and that this means that the said documents have not only been incorporated, but have been sufficiently pleaded. On this point, the petitioners cited several cases which are reproduced here. Petitioners further argued that the facts in Belgore and Ahmed, and Ipiazu and Oti, Ogu and Ekwere Madu, Ojuku and Eradua, PDP and INEC and others, and Soga and Igwede, and all other cases cited by the respondents are not the same with the facts of this petition. Those documents were never pleaded by reference or incorporation in those cases. Additionally, petitioners have relied on paragraph 17.2, first schedule to the Electoral Act 2022, and argue that the respondents have joined issues with the petitioners on those paragraphs. Having failed to seek for further particulars, they must be taken to have understood the paragraph. They relied on some cases. Now, resolution. I've carefully considered the submissions of the parties and the judicial authorities cited. It is right that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. General principle of law is that such pleadings must sufficiently and comprehensively set out material facts so as to ascertain with certainty and clarity the matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary if the case is to meet, to afford him the opportunity to properly respond to such case. Its aim is to bring to the knowledge of the opposite side and the court all the essential facts, therefore, is safeguard against element of surprise. Shodipo versus Lemini Kane, Odom and others versus PDP and others, Lassang and another versus Ishaku, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based, the relief sought by the petitioner, unquote. Subparagraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively, unquote. In addition to the provisions of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019, subject to such modifications as would bring same in conformity with the provisions of the Act. By Order 13, Rule 4 of the Federal High Court Civil Procedure Rules 2019, every party to an election petition shall ensure that amendments in their pleadings, and I quote, contain in a summary form the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively. Quote. By subparagraph 4 of that rule, such facts contained in the pleading must, and I quote again, be alleged positively, precisely, and distinctly, as briefly as is consistent with a clear statement. Quote. The aforementioned provisions contained in the first schedule to the Electoral Act 2022, as well as the Federal High Court's Rules 2019, state the mandatory requirements of pleadings in election petitions. The requirements for clarity and precision of fact required by paragraph 4 of the first schedule to the Electoral Act means that amendments must not be vague, ambiguous, or unclear, leaving room for speculation or conjecture, while the requirements of distinctiveness means that each amendment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the amendments in the petition, and ascertaining the allegations being made in the petition. Particular, paragraph 4 sub 1 sub D, relating to the facts of the petition, the grounds on which it is based, and the relief sought by the petitioner have been severally considered and interpreted by the appellate court. In Belgore and Ahmed Supra, the complaint against the amendments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general in terms. In that case, the Apex Court specifically held as follows, and I quote, pleadings in an action are the written statements of the parties wherein they set forth the summary of the material facts on which each relied in proof of his claim or his defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offenses in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4 sub 1 sub D of the first schedule to the Electoral Act and or Order 13, Rule 4 sub 1, 5, 6, and sub 1 of the Federal High Court Civil Procedure Rules 2009, unquote. Indeed, in PDP and INEC, the Apex Court was categorical when it held those, and I quote, On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election, non-conclusion of election, printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractices without providing particulars or the polling units where the alleged malpractices took place. The lower court was therefore right when it held as follows. Above the paragraphs above, in my view, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply the governments in the pleading must not be general, must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above, and I adopt it as my unquote. Indeed, on the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act relating to further particulars, the Apex Court held in PDP versus INEC Supra that, and I quote, an application for an order for further particulars is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary particulars as the appellant's was in the instant case, unquote. A sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings in paragraph 4 of 1 sub D of the first schedule to the Electoral Act 2022, on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 sub 1 and sub 2 of the first schedule, the Electoral Act 2022 relating to further particulars on the other hand, shows that whilst in cases such as Abubakar versus Eraduan, Ombugadu versus Sule, the Supreme Court had held that a respondent who complains of vagueness of arguments in an election petition should avail himself of the provision of paragraph 17 sub 1, first schedule to the Electoral Act, seek for further particulars or the direction of the tribunal or court. The decisions of the Apex Court, especially in PDP, INEC, Belgore and Ahmed, have specifically held that where arguments in the petition are grossly imprecise, generic, such arguments will be incompetent, liable to be struck out. Also on this EPRZU. It is therefore clear that the state of the law, as could be deduced from the various decisions of the Apex Court, is that the provision for further particulars, as stated in paragraph 17.1, first schedule to the Electoral Act 2022, will only come into play where the petition itself contains material or necessary particulars. In other words, paragraph 17 sub 1 of the first schedule to the Electoral Act 2022 does not bar a respondent from applying under paragraph 4 sub 7 of the first schedule to strike out arguments in a petition which are grossly inadequate, insufficient, devoid of material or necessary particulars. This is because the operational words in paragraph 17 sub 1 is further particulars, and this means there must be some material particulars already pleaded in the petition before further particulars can be sought by the respondent. As born from the Apex Court decision in Belgore and Ahmed, PDP, INEC, and EPRZU and OT, the law is clearly settled that specifying the particulars of polling units or places where irregularities are alleged to have occurred are material particulars in an election petition. Arguments in an election petition which allege irregularities or malpractices but fail to specify the polling units or places where the irregularities or malpractices occurred are bereft of material particulars, and such arguments are incompetent and liable to be struck. As specifically stated in PDP and INEC, the petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against the respondent in order to cure the incompetence of such argument. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, EPRZU and OT, and several others, on the mandatory requirements for stating material facts as provided in paragraph 4.1, first schedule to the Electoral Act. Contrary to the contention of the petitioners, the decision of the Supreme Court in Ombugadu and Sule Supra has merely reiterated the legal position relating to further particulars as provided paragraph 17 sub 1 first schedule to the Electoral Act 22. It has not departed from the above specific decisions of the Apex Court on the materiality of specifying in an election petition polling units or places where irregularities and malpractices are alleged to have occurred. Now, a look at the arguments in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular polling units or specific places where the alleged irregularities and malpractices have occurred. For instance, in paragraph 9 of the petition, where the petitioners avert that, and I quote, in appropriate cases, these agents raise complaints about anomalies where they occurred and reported such complaints to designated officers of the second respondent and the first respondent, unquote. The petitioners failed to specify the anomalies, the places where the anomalies occurred, the agents who complained, and the designated officers of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, where the petitioners allege that the first respondent, and I quote, suppressed the actual scores obtained by the petitioners by deliberately uploading blood from EC8As on the IRF in 18,088 polling units. The petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling units codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. Paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, unquote. They did not specify the polling units where they allege there were no elections. Incorrect results that were uploaded and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, unlawfully reduced and added by the first respondent to the scores of the second respondent, unquote. They failed to state their scores that were reduced and added that of the second respondent by the first respondent, and the figures that shows that the first petitioners won the election. In paragraph 72, 73, 76 to 78, where the petitioners allege overvoting, they merely stated that they will, and I quote, rely on the forensic reports of the election materials showing that the votes cast in the polling units in Ekiti State, Oyo State, Ondo State, Taraba State, Osun State, Kano State, Yobe, and Niger States exceeded the number of votes accredited on the beavers in those states. Petitioners failed to specify the polling units in those states where the overvoting occurred, the number of votes affected, the margin of lead, which they claim that the voters who ought to legitimately vote in those polling units. In paragraph 73 of the petition, petitioners only stated that they will, and I quote, show that in the computation and declaration of the results of the election, based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation. Petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. Paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on Form EC8As to establish that substantial votes were unlawfully credited to the second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic/expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection report, and forensic/expert analysis was attached and served along with the petition on the respondent. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petitioner. It is only in paragraph 62 and 64 of the petition where the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. That the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondents. And also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondents. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details of the polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, inflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners allege corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practices, while standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is beyond reasonable doubt. The PDP, INEC, Mohamed Wamako, Board of Customs and Excise versus Alhaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2, 3.221 of their submission, in opposition to the first response objection, petitioners appear to have conceded that in the averments of the petition, they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specified the figures of the votes or scores which they allege to have been suppressed, inflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets and forensic analysis reports which they have incorporated and made part of the pleadings by reference. See particularly on this paragraph 67 of the petition. Petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17(1) and 2 of the first schedule to the Electoral Act, they are deemed to have understood those averments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as the winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in his defense. Indeed, in all the cases of EFCC reign, Ekpomo Polo versus Edere Moda, Marine Management Associates Incorporated versus NMA, and Dingyadi and Omako Supra, which were relied upon by the petitioners, the documents which were incorporated as part of the pleadings by reference were served along with the pleadings on the advert. In considering a similar scenario, this court, by Ayola, JCA, as it then was, held in Nigeria Merchant Bank PLC versus Ayedun Investment Limited as follows, and I quote, "Before I part with this appeal, it is pertinent to advert one pleading question raised in this pleading in regard to the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such arguments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this suit. Although the principle is established that if an agreement in writing is referred to in a pleading, it becomes part of the pleading, and it is open to the court to give the agreement its true legal effect, irrespective of the term used in the pleading to indicate such effect. That proposition of law should not be used to cover such argument as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered at the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as Bank Genesis versus Petai Limited, ought to be defined, unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondents, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4, sub 5, sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, quote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petitioner's argument, it does not cover incorporation of documents into pleadings by reference. It is also noteworthy that the spreadsheets and forensic reports which the petitioners claim to be incorporating into the petition by reference are actually documents prepared by the petitioner's witnesses. In other words, spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have to obtain by subpoena. Being the petitioner's own documents, they ought to have served those documents along with petition on the respondent, so as to enable the respondent to counter same by engaging their own experts appropriately respond to same if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Agungwimiju Jesse, as he then was, how Jesse, held in Udiaga and another was Omegara, as follows, and I quote, the argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort to point in the pleadings the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, massive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? The arguments in the appellant's pleadings should have contained details of the allegations and complaints which the respondents could reply in detail in their own pleadings. Appellants expected the respondents to reply to the various specific allegations contained in the witness statement filed along with petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. The pleadings must show the facts disputed, while the witnesses would give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the place of necessary arguments in pleadings, unquote. Indeed, in a presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states, and the Federal Capital Territory, it is unimaginable that arguments in the petition which merely allege irregularities and/or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for further particulars. Tibel Gore Ahmed and PDP. Also, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. Ibusari versus Adepoju, Oyetola versus Adeleke, and Anazong versus Onubogu, citations on the. It is in this respect that a petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of a party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others versus Adu. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of the 4, sub 1, sub D of the Electoral Act 2020. In accordance with paragraph 4, sub 7 of the said schedule, the said paragraphs are consequently hereby struck out. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that while paragraph 57 and 58, whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, petitioners have in paragraph 65, 67, 70, and 71 stated that they will rely on the report of the inspection. Additionally, the first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with the Electoral Act 2022. They have also alleged that they have scored majority of lawful votes cast and should be declared the winner. Relying on some cases which are produced here, first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5, sub 1, and sub 2 on the other hand, for being inconsistent. Conversely, the petitioners contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They referred to the alternative reliefs at pages 35 to 37 of the petition, relied on some cases which are reproduced here, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adigije versus Nwaugu and others, this court, Ogunwumi Judiciary, as he then was, held that, and I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance, and in the same breath claim that he won the election by a majority of lawful. Petitioner may plead the same set of facts to ground alternative reliefs. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief, as the party must decide which relief is best supported by the evidence on record, unquote. See also on this Metal Construction West Africa Limited versus Abodering, citation given. In any case, the first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, wherein petitioners averred that the first petitioner was duly sponsored by the second petitioner, on whose platform the first petitioner contested. I therefore have no hesitation in discountenancing this ground of the. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. The second category of the respondents' applications that challenge some of the grounds of the petition and or the competence of the petition are as follows. First, respondents' motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 33 to 79 and reliefs 5, Roman 1 and 2 of the petition on transmission of election results for being cut off by issue estopel. 2. Order striking out paragraphs 20, Roman 1, 21, 23, 24, 25, 26, and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds, which are reproduced herein. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estopel in relation thereto, as well as the issue relating to competence of the reliefs sought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in substantive case. Wanko and others versus Eradua. Ocholi on Onojo James, SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's locus standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, or to some paragraphs of the petitioner's replies. Lack of locus standi of the first petitioner. The second and third respondents and the fourth respondent's motion filed, their motion filed on the 8th of May 2023, also objected to the first petitioner's locus standi to bring this petition. The principal contention is that the first petitioner was in contravention of section 77 sub 3 of the Electoral Act 2022. They argue that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members, second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act 2022. Since the first petitioner is not in the membership register submitted by the first respondent to the first respondent by the second petitioner, the first petitioner lacks the locus standi to challenge the outcome of the election. By contrast, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned. The court lacks the jurisdiction to entertain it. They relied on the cases that are reproduced here. The courts have consistently held in a plethora of cases that the issue of membership of the political party is an internal affair of the party. It is not a justiciable issue, and courts have no jurisdiction to entertain it. See Enang versus Asukwo, others, Sani and Galadima, and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioner. The provision of section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, first petitioner has satisfied the requirement of being a member. Second petitioner, as provided for in section 131 sub C, the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership, second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. First respondent in his motion of 19th of April 2023 and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election. The petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. Place reliance on JGD and INEC. Buhari and Obasanjo, citations on the record. No position, however, petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to the petition. The petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party. By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Eradua, Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties at an election. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate 2 or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of JGD and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution would have ceased being a governor of Yobe State if the case made out in the petition that you could not combine the offices of governor of Yobe State, acting chairman of the All Progressive Congress, is sustained. In this case, Abubakar Atiku, the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition, and the petitioners hearing have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPEPC 05-2023, which, as mentioned in the earlier part of this ruling, this court has consolidated with the petition signed with paragraph 50 of the first schedule to the Electoral Act 2020. This ground of objection to the competence of the petition is unmeritorious, is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the reliefs which the court can grant in an election petition are statutory, as provided in Section 136, sub 1, sub 2, sub 3 of the Electoral Act 2020. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply, the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 petitioners reply for offending the provisions of the first schedule to the Electoral Act 20. Second and third respondents' motion filed on the 13th of May 2023, seeking for order striking out petitioners' reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath with failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply, the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply, their respective replies, or in the alternative, the paragraphs thereof, which they have variously listed above. Their essential contention is that the replies, or in the alternative, the paragraphs thereof, have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or a hash of the facts contained in the petition, contrary to the provisions of section 16, paragraph 16, sub 1, A and B, the first schedule to the Electoral Act 20. Respondents replied on several judicial authorities, which are reproduced. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent to the Electoral Act 2020. They relied on Silva and INEC, PDP versus Ezeonguka, citations on the record, and urged the court to discountenance the objections of the respondents and uphold the petitioner's reply. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, petitioner's reply in answer the new issues of fact. So, however, that A, petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him. Quote. By the import of paragraph 16 sub 1A of the first schedule, petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not, in so doing, amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1A are, quote, new facts, grounds, or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of the petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awoduyi Lemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new, the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation. The defendant's averment was introduced pleadings for the first time and therefore unique and novel to his pleading, unquote. A careful examination of the petitioner's petition, the first, second, and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduced new facts in their replies, the respondents' replies, which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A, the first schedule to the Electoral Act 20. Paragraphs 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in their petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental fair hearing guaranteed by section 36(5) of the Constitution of the Federal Republic of Nigeria 1999. Since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC, others. Maku and another versus Al Makura and other citations. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition is only a response to paragraph 7 and 8 of the petition. But the petitioner's argument in the same paragraph 15 that the first respondents officials at the polling units failed to give clear copies of the results of the election from ECHA to the petitioner's agents, as the pink copies given by the petitioner's agents were very faint and unreliable, is a new fact which tends to amend the petition. Paragraph 16, Roman 1, 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purport to respond to new issues in paragraphs 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply, the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply, the petition latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations. The fourth respondents, which the fourth respondent has no opportunity. Being contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also here. That indeed is the rulings on the respondents' objections, various objections.
Well, as I was trying to explain earlier before we went for the break, we'll take all the judgments. After that, my learned brothers will now their own order to save time. Because the petitions are consolidated. So now we will go to the main petition in petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 25th February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the three statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition and determine the merit otherwise of the petition in interest of justice. At trial, the petitioners opened their case to tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents who reserved the reasons for their objections to the stage of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents file separate addresses on their objections along with their final addresses. Proof of their petition: the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses, give evidence, and adopt their addresses, witness statements on oath, and reserve the rulings for their objection to the stage of final address. That prejudice to the objection, said witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. Fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents and that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and extended their respective final addresses, including separate addresses, support of their various objections which they raised during trial. So we shall now consider the respondents' objections to the competence of some of the petitioner's witnesses and to the documents tendered by them during trial. To save time, skip the addresses of counsel, go to the resolution of those issues. So the resolution of the respondent's objections to witnesses and documents contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath of those witnesses of the petitioners were not loaded along with the petition, but were only filed during trial, contrary to paragraph 4.
Are you there, Masik Mark? Yes. So what do you think so far? What do you think is, because the body language in the court, the evidence being presented so far, I'm seeing that they're citing all the injustices they have done in the past in order to uphold whatever judgment they are leading towards to. Do you see that? Because the fact is that people are listening and they speak all this long grammar and they quote and cite cases. But most of those cases that they are citing also represented the injustices that we have seen in the past. So citing those cases does not justify the current judicial system that they are upholding. Yeah, so
okay, can you hear me? Can you hear me? George, can you hear me now?
I can hear you now. Can hear you. Go
nice. Ahead. Yes, I was saying something, even though the audio was mute. Very good observation, George. Also, we're saying that this is my observation on this verdict today. Number one is, yes, I know so far the verdict, the readings have not favored majority of Nigerians. But George, there's something about when you start a judgment and you start by giving the winning side, you start by giving them some props, you know, you start by giving them making them look like they are advantaged. Because how I'm seeing this is eventually, George, I think this will play out well for the opposite party, the Labour Party, and maybe PDP. George, this is my observation. The verdict so far has been to the favor of APC. Shetima's dual nomination, they strike that out, and now they are trying to strike out the PDP verdict also against LPC. So this is what is playing out so far. But George, I think eventually, because we are going on to about 4-5 verdicts, eventually, George, I think my own observation is it will begin to come to the favor of Labour Party.
You know, I would have been excited, you know, if we were dealing with a country or that have had the history of maintaining rule and order. But I tell you what, everybody is glued on this tribunal today. But coming into
George, here with us on our own network is 25,000 people watching, because we're all anxious. We're all eager. We're all very, 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 we want to see a change, you know, and this shows how Nigerians are really expecting change in Nigeria. We want to see a different thing play out in governance, in our democracy. So
that's
everybody
exactly my point.
That's it,
That's
George.
exactly my point. My point is, if we have had a history of maintaining law and order, of the judicial system coming out to give us fair and equitable judgment, I can guarantee you that at least 80 to 90% of the people glued on this, because millions of people are watching from around the world.
Yes, from different networks,
from my own experience with what has happened in our country or has been happening in our country, the impetus of our people to just, you know, negligently just do things without any second thought. Whether look at what is happening in Nigeria. If you were to bring some of these justices and proof that they were bribed, nothing will happen. It will just be a news for a weekend. Then after that, everybody goes home. They go start chopping their money. All things being equal, I can get excited. But I can tell you that all things are not equal. I'm even to the verge of saying, to your tents, O Nigeria, what portion do we have in this judicial system? You've been raped by the politicians. You are being raped right in your presence right now with all these narratives and all this long grammar and quoting of, cases where they have been bribed and favored the wrong individual. They're quoting it as if to give them as precedence to what they are doing today. Because when you listen to the tone of their voices, and that's part of the thing about being a lawyer. To me, lawyers think from the two sides of their mind. It's almost like politics. That's why they can become the best politicians, if you ask me. Because they can stand on the right today, tomorrow they turn to the left. If he favors them on this side, they will argue. If he favors them on that side, they will argue on that also in order to win a case. But that doesn't it doesn't have anything to do with the man's conscience, because facts are facts and truth are truth, and there is nothing you can bend it. Like I quoted this morning. Yeah, I quoted this morning. We've come to the point where wrong is right, right is wrong, white is black, black is white. Nobody, it's all blood in our own presence. But I'm still neutral, and I'm still listening, and I'm still sitting under the oak tree to see how this thing will pan out at the end of the day. But if you ask,
I want you to be optimistic. Don't lose hope. Don't lose your eagerness to see a new Nigeria. So viewers online, those following us, we have lots of youth out there. Bring out your comments. Let's
discuss your comments, please.
Yeah, Mohammed Ali just made a sign of, I'm wondering what is happening. And Joanne Edwards says blessings. Let's see how that comes out. This is it. Today, the 6th of September, 2023, we are watching live proceedings from the courtroom in Abuja, Nigeria, on the Nigerian Presidential Election Petition as the court gives out its verdict. Take note that PDP political party, Labour LP political party went to the court to challenge the February 29 election. And today we have the verdict. We're hearing the rulings. Now, what we observed from what is happening, viewers listening to us, George, one of what we observed is, number one, we are not seeing the real face of the man reading the verdict. What we're seeing,
I wonder why they're hiding his face. Why are they giving us
is a cartoon face.
It's supposed to be live.
Maybe it's not even the voice of one of the judges. Maybe it's just a random person that is speaking using his voice to make the utterance, and they've hid their faces. They've closed the voice. So these are some of the things we see, and we begin to wonder, why are they doing this? Why are you not transparent? I mean, why do you hide things? Why do you want to bring somebody's face, somebody else's face and somebody else's voice into a situation that is as crucial as this? When we need to hold people accountable, we need to say, you, this person, you were the one that ruled against this, blah, 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 So, George, that's what we're noticing. The other thing we noticed in the courtroom is that the Labour Party presidential candidate and his vice, Peter Obi, and his vice, Ahmed Adati, are not present in the courtroom. So they have the chairman of Labour Party representing them, and that's Aburi. And also we noticed that the Shetima, the vice president, the INEC vice president, is there representing his boss, Tinubu, that we are all standing against today. So viewers, don't lose hope. Like I said earlier to George, Sometimes when a ruling begins by giving favor to this person, the other person there might eventually be the winner. That's how I see it, George.
Well,
George, what do you think?
To me,
Mm-hmm.
I am not saying that I want Atiku to win today. I'm not saying that I want Obi to win today. I'm not saying that I want Tinubu to win today. All I want is Nigerians for the very first time to win today. Let their desires be granted. It's not about Obi, Atiku, Tinubu, Shetima, Dati, or whoever else.
Okowa.
I think that this nation, the people, the populace, they've been raped for a long time. Look at what is going on with our leaders, my brother. All we need, all Nigeria needs, is simply good governance. Give the people what they deserve. This recycling of government, this recycling of leadership, there ought to be a time when Gabon just got tired of being tired. Niger Republic got tired of being tired. Look at some of these Francophone, neo-colonial places, what has been going on. A 35-year-old will stay in his mother's house after graduating from university simply because there are no jobs. And we're here playing with them. The infrastructure is not there for logistics to move food from one area to another. Insecurity all over. Decisions are being made, irrationally, without thinking of the ramifications over people. Because you on top, you just make decisions, you change the color of the money, you come and shine your face as if you're doing something. I think it's enough time for us, enough time for the people to finally say, take a breather. Wasn't it the Senate president that would say, let the people breathe? I'm telling you, people, they need to take a breath of fresh air, finally. Both sides of the aisle know the truth. Mr. Christian.
Yes.
Adimonium, how do you say that? Adimonyma,
Christian.
So we all know the truth. Yes, we all know the truth. Because God created it with such conscience to know left from right. But this is what we are going through today. People's hearts are bleeding. The point is that some of these people that live in their sealed houses have no clue whatsoever what the common man is going through out there. When they are forced to fast breakfast and dinner just simply because they only have enough for lunch. This is what you're seeing out there today. Look at the value of our naira. Can you just imagine a young man who had like $1 million naira, prior to all these shenanigans that is going on? Today, the value has dropped drastically. Prices of everything is doubling in our country. And we have no clue whatsoever how to turn things around. We're just going by trial and error. If it works, it works. If it doesn't work, we don't think before we act. How long would it be? Okay, look at this now. All of a sudden, I'm hearing that what's his name from River State? What's his name again? Carrying his thugs, in the streets of Abuja. This is okay. The military is there, the police is there, but also we're going to get some hired help. The Otimpus. These are the people there. They're just noise makers. Now you're going to have them to go there while an individual from
you're talking
Lagos
of
State,
Asari
one individual from Lagos State said, if you, an authority, cannot protect our businesses, maybe we need to call to the eastern part of Nigeria to bring the IPOB to come and protect us. We don't know the history of that man up until today because they arrested him, put him in prison. While Asari Dokubo can come and flash gun all over the place. The law is one-sided, but I can guarantee you one thing. God is watching. All we need is a plain ground for everybody to operate fairly, judiciously, because if you begin to turn justice upside down, the ground is listening. That's one thing people do not understand. When Cain killed Abel, the first thing that God said to Abel, the blood of your brother Abel is crying out to the ground, to me, for justice.
Sir George, let's go back to Abuja. Let's see what is happening. I think there's a break again for a second verdict. Viewers around the world, thank you for tuning in, bringing your comments, get involved in what is happening in your country. It's our country. No man owns Nigeria. Nobody, no particular person or group of person own Nigeria. We all own Nigeria. As long as you're born, you're from there, your origin is from Nigeria, you are a Nigerian. You have the right to all the factors and everything as a Nigerian. So let's not shy away from what is happening. Don't get discouraged also. Stand and let's see how they play out so that we know where to go. We know what to do next. But believe me, God is on our side, and we all stood up on that February 29th, and we will not back down. So don't get discouraged. Let's see what is happening. So we're going back to Abuja now. George, I want to thank you for being live here on Nigerian Presidential Election Petition Day, the Judgment Day, like we call it, a day when the verdict is being read out. So people are writing, they say it's long story. They are saying too many things. They want to hear the final verdict. But this is legal proceedings. There's a way the courts does their thing. There's a way lawyers do their thing. So let's follow them in what they're doing, and eventually we'll get the results. So stay tuned. Thank you for being on ground. Thank you for following up on Schengen Story Media. My name is Mark Godwin Iwejuwan, and we'll be right back with you after some other verdicts are read out. Thank you. Thank you, George.
Please continue.
Comments? Yes.
Subpoena witnesses in election petitions, delivered by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed by filed at the registry of this court by the Petitioner Council, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by summons as stipulated in paragraph 42, sub 1 of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. Earlier, from the provisions of that paragraph that is a person summoned by the court suo motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, 2 flash drives containing third annex consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is a staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is a staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Day, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general election. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS health dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious. This is a serial matter, it's not the last one. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives election, conducted along with the presidential elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert, engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as exhibit PCR, was, however, addressed to him personally and not through INEC. It's pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PF2, Tender 3 PW4. Exhibits PCG1 and PCG2, Tender 3 through PW5. Exhibit PCH1, Tender through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, Tender through PW7, and exhibits PCK1 and PCK2, Tender through PW8. The said exhibits are, I have estimated them in the judgment. The respondents' essential argument is that since the subpoena witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4(5)(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoena witnesses, whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4(5)(b) of the first schedule of the Electoral Act 2022, the documents admitted through them.
George.
Yes.
We're listening. This is it. Comments are coming in. Adimonema Christian is writing. Also, Ahmed Lukman is writing. Ahmed said, "May Almighty Allah grant us peace."
That's right.
That's a beautiful thing to write, Lukman, and that's what we need now: peace. But we can't have peace if there are some issues to be settled, and we need the peace, but we need to also settle our democracy. We need to settle our governance. George, what do you say?
Well, Christian is saying Nigeria is blessed with many things. God bless our country, but youths are suffering. No jobs. Someone we spend millions of naira in university. When the person graduates, there's no job, to give to them or for them to help their family. Yeah, this is actually one of the pains that is going on, that has been happening. If you look around, most of the countries that have disengaged from the Francophone people, is simply because these countries have raped Africans, taking advantage of our resources, and leaving the leaders, only the leaders, to be enjoying, while the rest of the masses are suffering. We're coming to the point in our generation now where everything is visible at the palm of your hand. In the past, they could lie, hide things, but today, things are happening live. When it's happening in Russia, we're seeing it live. If it's happening in UK, we're seeing it live. Anywhere in Africa, we can see it live. Things happening. So it is not that easy to lie and get away with it. That's what we're doing now. And this is the last stage of that visibility that will eradicate corruption from our country. But one thing that I have seen is that most of us we've been bamboozled with tribalism, ethnic and religious bigotry and all those type of things. All of a sudden, we begin to look at each other rather than looking in the same direction together. We forget that diversity is our strength. That when we all come together with our differences and table all of them, Your weakness will be my strength. My strength will be your weakness. All of a sudden, I can meet you at the point of your need with my strength, and vice versa. This is something that they have tried politically to divide our nation. Hausas will be saying Hausa, Fulani will be saying Fulani, Yoruba will be saying Yoruba, Igbos are crying Igbo, Ibibio, all those things. No, we are all one Nigeria. And I think it's time enough for us to forget about our ethnic origin. Let's focus on that building in Nigeria that will be that giant of Africa for real. Because we are nothing but jokes now. I have friends all over. You know, the question I have, you know, so many people have already asked me so many times. Oh, you guys are the giant. What are you gianting? What are we gianting? Are we gianting corruption, showing the rest of Africans the way to deceive ourselves and keep on still smiling? No, it is time for us to look on the ground, join ourselves together as one nation, and eradicate this nonsense. Look at what the political system did. We've been dealing with, with the security apparatus in Nigeria. They've done nothing for us. DSS is as messed up as they can be. The police is the same thing. Now we're dealing with the third arm of the government, which is the judiciary. And this is it. If the judiciary fails, what is it that a Nigerian can count on in the three arms of the government to say, take a breather, that we are heading somewhere? If these people fail us today, there is no more hope. I am telling you this for now. Thousands are watching this because their hope is still lingering, that maybe by the thread, a little thread that is holding, they can be able to say, oh, finally. But if this one fails out today, where will we be? What is it that we can count on? There's been a lot of brain drain. People are running away. Do you know how many people are dying on their road to find sustenance? They cross over many rivers. Moms are losing their children. People sometimes, they carry their own load, everything they have on their head. While that thing is about to fall and they're trying to grab it, they will fall to their death. Why? Because of this nonsense that we're going through in our country. They want to survive. They would travel thousands of kilometers and miles just to go to another country to survive, while we have Nigeria as the giant of Africa. If this judiciary fails us today, I want to ask the question. I want somebody to please come out and encourage me that there is still hope. Because if they fail us today, as far as I'm concerned, it's over. That's it.
So let's watch.
We all know the truth. We want the truth to come out. Let's watch. Come out. Don't bend the truth. Don't come and think that we are fools. The point is that they don't care whether we know it or not. They're just going to do what they gotta do and then just move on with it.
Oh, okay, so George, let's go back to the courtroom. We're seeing some strange movements. Let's understand what's going on. Thank you very much, Sir George. Thank you for those words.
In the instant case, EW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by a second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed on 20th March 2023. Obviously, the report Exhibit PCD1, PCD3, was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, he admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. He also admitted that the report she presented in exhibits PCJ A to F are public information hosted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are persons interested in the outcome of this proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, he is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, exhibits PCD1, PCD3, PCE1 to PCE4, PCF to PCG2, PCH1, PCJ1, PCJ2, PCJ3 A to F, PCJ4, PCK1, and PCK4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby extended from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection to exhibit PBP1 to PBP21, the IRF report for Adamawa State, on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCB1 to PCB6, referred to by the petitioners in response to the objection, are IRF certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and River States. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually Beavers reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of exhibit PBP1, PBP21. The blank IRF report exhibits PCA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from Annex IRF portal and were certified by Annex as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by Annex authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixon, where the Apex Court held that the computers from internet-generated documents printed from the website of a public institution is a public document. Only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 admissible. That I've started the victim of Supreme Court by a cast JSC Court. Exhibits PBP1 to PBP21 having been downloaded from ANIC report and duly certified by ANIC are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive tendered by PW5, the staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2023 final report. As rightly observed by the fourth respondent, the photocopy of the document is certified by Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of them to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as it can be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and why he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. The Omiseri and Arebashola, Manuel vs. Umana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-a-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. So many they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to CCC, that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore, Ahmed, Piazu, and Oti. In the latter case of PDP and ANIC, the Supreme Court was categorical on this mandatory requirement of specificity in averments of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting, several polling points, corruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars, or the polling where the alleged malpractice took place. The lower court was therefore right when it held as follows. Paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be charged. The fact that a party can file further particulars or deny in a reply the vermin in the pleading must not be general, it must be specific as to facts. The settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. That's where allegations of non-compliance and corrupt practices are made, such as in the instant petition. The polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent to its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practices in the same set of facts pleaded above. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Oyo, Ondo, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioner failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. In paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioner failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blood results downloaded from IRF and contained in 4 boxes, the petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units to which those blood reports led is an impossibility because the results are unreadable. The details of most of the polling units are stated in PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report of PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IRF portal. He did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints led even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheet. Those paragraphs read as follows. Paragraph 7, the petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner, and the conduct of the election thereof, acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8, in the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election material.
George, I want to note also that it's strange that the man is reading he's reading this verdict and he's stammering. And now this is supposed to be their writing. Is that not so, George? Their writing, this is supposed to be their writing, this is supposed to be their conclusion. And why is he reading it as if somebody wrote it for them? And the other thing, again, I want to note is a lot of people are sleeping in the courtroom. They are tired, probably. Many lawyers are sleeping. Many of the representatives and officials are sleeping. So why are they making it so? Why is it so cumbersome? Why is it taking this length of time? Why can't things be summarized in such a way that we get the focal points, the punchline, boom, 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 and we're out? Also, taking note of what Chidozie Ndubisi has written here. He said, it's sad that the rule of law has no place in Nigeria. This is a mere window dressing. Nigerians are one of the smartest groups in the United States, yet I look at our leaders in the executive, in the legislature, in the judiciary, and I weep. I often wonder how such smart people, how such smart and talented group could end up with the worst representation in government. George, that was from Chidozie Ndubisi. What will you say, George? The short break we have here. George, your line is closed, on mute.
They use long drama, long narrations, long language. They use it to tie you down, to tear you up so you will lose focus while they're just bringing it all. So that's what you're seeing here. I told you, it's all about technicalities. What I have seen here so far is one-sided type of government. They go in there looking for escape routes, loopholes, not balanced in any way whatsoever. Wherever they can find loopholes, they will use it. I mean, they're talking about, okay, the people that were, that some of these other political parties, presented their evidence from the local places where ballots were being, people were voting. Now they turn it around and twist it around and say, oh, these are agents of the political parties. Yes, yeah, the agents, they were there. They saw the shenanigan that was going on. And that's the reason why they were able to grab what they could as evidence that they had something wrong was going on in the polling units. But they're going to turn it around and say, these are the people that were hired by political parties. No, we are bringing you evidence and you're saying you don't know how we gathered those evidence. Yet what you have is all flawed. And that's what you're presenting to the public, finding loopholes to turn it all around. Nigerians, you are listening. It's not me talking. You are listening. So the judgment is you. You are the Justice Department, the Judiciary, the Tribunal. They are the ones that are, today we are trying them finally to see what they can do and what they have done to malign, to destroy the institution that we're supposed to be building in that country. So you be the judge. They might be wearing all this white stuff in their heads. You be the judge.
Adimoyema Christian is still saying a lot. He says, are you people sure this court is going to end today? Christian, we are also, we don't know. Because really, since it's open to the public, I would have, if we had a say or suggestions to make, I would have suggested, since it's open to the public, why not just summarize things and make things a little bit easy to understand, instead of putting us through these legal terms that many people don't understand, saying a lot, using technicality, like George said, to
They're not trying
out.
to please you. They're not trying to please you.
They're not trying
what
to
they're
please us.
trying to do is they're trying to manipulate the system with all the legal lingos and all the long narrations and analyses and all that, all screwed up. I'm listening. I'm here. I mean, I can consider myself to be, an average intelligent man. I'm listening to them. I see where they're coming from. I see the angles they're taking. You understand? And I'm quite sure thousands of us watching today, they're watching too, and they're seeing it. So the judicial, the tribunal they are sitting. We are judging them today. Because finally, after this, we'll make it a determination whether we're going forward or backwards or we're standing still. Simple. I just want the truth. Don't twist and turn around the truth, because we all know the truth.
We are watching from here. We are watching.
If it is wrong, you want to stay on the left. You can stay on the left. It's still your choice.
It's still your choice.
Yes, but please don't play with our intelligence. This is what I'm seeing here. It's very sad. Very sad.
Thank you, George. So viewers, we are watching out here. We have 19,000 viewers with us on this platform. George and I, George Chukwu from Toronto, representing the Schengen Story Media there in Canada. And we are observing, we're following live proceedings in the Nigerian Presidential Election Petition. And you all are watching live. We're all following it up. We wish it will be summarized. A lot of people want to go into other things. This is midweek, and we all have what we do, but we need to also follow what is happening in our country, Nigeria. Sadly, they are reading it out, and we're watching. So thank you for staying in tune. Thank you, those of you that are following, writing, Ndubisi, Christian, Lukman, a lot of you writing from different corners.
Yeah, bring your comments. Bring your comments. Don't allow your emotions to be stifled.
That's correct.
Lay it out. Bring it on. We're here with you.
We're here with you. So we're Nigerians. We are still that dynamic people. And in fact, these things that are playing out shows that it's a new dawn. Nigeria is changing. We're changing the narrative. People are now interested in governance. People are now, because we never used to put our eyes on it before. And that's why we got them this deep in the menace, because we didn't care before. So now we care, and we care because it's our life, it's our country. We have no other place to go. Even if you're in any other place as a Nigerian diaspora, you still have to come back home. Home is home. out there, you're still, wherever you are, even with your passport, whatever you have, you're still a stranger. But in Nigeria, that's your home. So we need to put our eyes on our country, follow what is going on. So thank you all for tuning in. Thank you for the follow-ups. And let's go back to the courtroom. Thank you, George.
Yes.
The resolution without objection on the petition objection to exhibits RA8 and RA9. An examination of the petition shows that in paragraph 28, they have challenged the second respondent qualification to contest the election on the ground that he was fined a sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightfully submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraph 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, and confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, a centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants against the second respondent. The respondent shall found and rely upon a copy of the said letter of February 4, 2023. Signed by Michael M. Bonner. Yes, the date is wrongly stated, corrected. From the foregoing, it is obvious that issues were joined by the parties when the indictment alleged by the petitioners and Exhibit RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, Exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while Exhibit RA9 is the reply to Exhibit RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigeria Police and are therefore public documents under Section 102E of the Evidence Act. Certification by the Nigeria Police Force is a confirmation that Exhibits RA8 and RA9 are true copies of those documents which are in their custody. Onwuzurike and Idoziem, Abaje and Koka. With regard to the petition objection to the relevance of Exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioners have not joined issues with the second and third respondents in their reply to the second and third respondent reply. That the court of law adjudicates only on matters over which parties are in dispute. The Adedeji and Olosho, another Trade Bank PLC versus Benelux Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to determination of this petition, hereby is countenanced. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioners have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking. And in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore a considered view that Exhibit RA 11 and RA 16 are relevant to these proceedings. It is no objection to them, hereby discountenance. As for Exhibits RA 17 and RA 18, the petitioner's reason for objecting to them has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's locus standi to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's locus standi whilst resolving the respondents' preliminary objections. We have already resolved them in favor of the petitioners. Therefore, this objection has been overtaken by our ruling on the preliminary objection. On the petitioner contention that Exhibit RA 19, the report of the committee on the location of the federal capital Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and return elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which renders Exhibit RA 19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA 22, we observe that the document is the same as Exhibit RA 2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. Standard of Exhibit RA 22, which is not even certified, is therefore a surplusage, thereby discountenance. With regard to the objection to admissibility of Exhibits RA 24 and RA 25, which are CTCs of pages 28 and 29 and 27 of Nigerian Tribune newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA 27, the ECOWAS preliminary declaration, is a private document. Said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. It's undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA 27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA 27 is hereby expunged from the record. As for the objection to Exhibit RA 28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it's clear to us that the document was neither pleaded nor listed or referred to in the statement of RW2, as rightly argued by the petitioners. Exhibit RA 28 is inadmissible. Accordingly, it is hereby expunged record. Now we go to the merit of the petition. Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their respective final written addresses, starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Learned Senior Counsel for the first respondent, A.B. Mahmoud SN, distilled the following 5 issues for determination. A, whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election 25th February 2023. B, having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of election 2020, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time amounted to non-compliance to Electoral Act, whether such non-compliance substantially affected the outcome of the election. C, whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D, whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by a majority of lawful votes cast. E, whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes, cast with 25% of the votes cast in over 2/3 of the state's federation. The Learned Senior Advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for determination. 1, having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, judgment of Federal High Court, and FACA BJCS 1454/2022, Labour Party and INEC delivered on 23rd January 2023, which is X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 26 February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2, in view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission, INEC, delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 25th February 2023. 3, Upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022 and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria, or considering the constitutional petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, Senior Counsel for the fourth respondent, also nominated 4 issues for termination as follows. 1. Whether having regard to the issues joined and the evidence led on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the district court in case number 93C4483. The petitioners have established that the second respondent was not qualified to contest the presidential election held on 25th February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority of lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. On the part of the petitioners, their lead senior counsel, Dr. Livy Uzoku SN, distilled the following 3 issues in the petitioner final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, subsection 1D, 142, subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2022. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Electoral Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25th February 2023. So in response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for examination with the earlier filed on 18th May 2023 during the hearing session. These are: 1. Whether the second respondent at the time of the presidential election held on 25th day of February 23 was not disqualified to contest the said election by virtue of the provision Section 1371D of the Constitution of the Federal Republic of Nigeria amended. 2. Whether the third respondent at the time of the presidential election held on 25th February 2023 was qualified to contest the said election as the vice presidential candidate to the second respondent. If answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3. Whether the presidential election held on 25th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and any guidelines and regulations for the conduct of the elections 2022 made pursuant to the Act. From the pleadings, the evidence adduced, and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1. Whether, having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the evidence and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. 2. Whether, having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. 3. Whether, from the totality of evidence adduced, the petitioners have proven that the presidential election held on 26 February 2023 was invalid by reason of corrupt practices. 4. Whether, from the evidence adduced by the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. Well, we stated earlier, we have summarized the submissions of counsel. We didn't want it of reading them out. The first issue is whether, having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 26 February 2023. Well, I think the issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution, this issue. The only exception is the allegation on the issue of the second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 30 of the petition, is that the second respondent is disqualified from contesting the presidential election because is stated in paragraph 28 of the petition as follows. The petitioner further plead that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in account of 263226 held by First Heritage Bank in the name of Bola Tinubu, funds in accounts 394833134, 394833396, 4650279566, held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in accounts number that are held by Citibank International in the name of Bola Tinubu defendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, of a sentence of imprisonment or fine or any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by a competent authority, or any other sentence imposed on him by such court or tribunal. A careful examination of the above provision shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary 6th edition at page 1081 defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights, as unpunishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. A judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph E of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, the provision of section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held in Action Congress versus ANIC as follows. The disqualification in section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt or embezzlement or fraud in derogation of the safeguards in section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to section 36 of section 5 of the Constitution of the Federal Republic of Nigeria 1999. Whereas conviction for offenses and imposition of penalties and punishment are matters appertaining exclusively to judicial power. See also the cases of Amici and Anis Omuwaye versus Attorney General of State, Karim and others versus Shimkafi. A careful perusal of P5 relied upon by the petitioners showed that the case number 193-CV04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank NA. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held inter alia that Section 17 of the Advance Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture of property under Section 17 of the Advance Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Baths Limited versus Federal Republic of Nigeria, Alison Madueke versus ESCC. From the legal definitions and judicial authorities stated above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement of oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 say in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1, no criminal charge was filed against the second respondent. 2, the second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3, the second respondent did not go through a criminal trial. 4, the second respondent was not convicted of any crime or any criminal activity. 5, no sentence of imprisonment was imposed on the second respondent. 6, no sentence of fine was imposed on the second respondent. 7, no form of sentence was imposed on the second respondent. 8, case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonal criminal sentence was imposed on the second respondent 49, the second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that on the record checks for the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, the Centralized Information Center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the US, even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied with the exhibit RA9 and stated as follows, quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC, ABJ, volume 24, 87, regarding Governor Bola Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest records, warrants for Bola Tinubu, POB 29, date of birth, March 1952. For information of your department, NCIC is a centralized stipulated how conviction outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2, a certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case, not on the weakness of the respondents. Okereke vs. Umahi, Menike vs. PDP, Omushore vs. Rebushola, Ucha and Elechi. The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1999 Constitution because he was fined the sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 137(1) will be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated same with the general class. The Uchuku Nata versus Attorney General Anambra State, Martin Freuder and others versus Nejo and Co. Nigeria Limited, but FMBN versus Olo. In both paragraph D and E of Section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced. Then it means, in respect of the sentence for offense of dishonesty, the two paragraphs must be read together. That for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a presidential candidate from contesting the election. It is also a cardinal principle interpretation of the Constitution that relevant provisions must be read together and not disjointedly. Abegunde and the State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of Section 137 of the Constitution of Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. Consequent issue 1 is hereby resolved against the petitioners and in favor of the respondent. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Again, we shall skip the submissions of counsel. Well, the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent, Grant 2 of the petition, which they raised at preliminary stage. As well as reliefs 5.1 and 2 of the petition, as and collation of the
George
of the subsistent judgment of the Federal High Court in suit number FHC-ABS.
It's obvious the way it's going, George. I know you're watching from that end. Viewers, you are still tuned to Schengen Story Media. We are on live covering the Nigerian Presidential Election Petition. And today, the 6th of September, is the day the verdict is being read. And George, what are your observations so far?
Well, what I'm observing is what I expected. I told you, all things being equal, we might be expecting something a little different. But in this case, all things are never equal with our country. All they did was wasted our money, wasted our time, wasted everything else. And I know the reason why they want to just come out here and read all this long story and everything else, just basically to show to the world, oh, we are clean, we went through the process, everything is okay. That's all it is. That's all it is. So
That's all it is. That's
it's
all
quite
it is.
clear. It's quite clear. I
all
see
it is.
why
I know you.
Jagaban has
Yes.
successfully maneuvered and muscled himself into leadership by force. And this is nothing but manipulating the system, billions of dollars and everything else that is happening. So we're here watching.
That's what it is.
That's right. Eddie just said it seems the judge reading is trying to accuse the petitioners. That's exactly what it is.
That's exactly what it is. Eddie, you said it. That's how we see it also. It is not like a neutral thing. He's talking as if it's him against us,
That's and what it is.
Yes, that's really crazy. Accusing the, saying things. I mean, they didn't even write the script well, and he's fumbling over words. He's not saying, he's looking through the lines as if they wrote it for him and gave it to him. It's terrible. Take note also, we're not seeing his face. It's a cartoon face of the so-called Judge Tusaniama. I don't know that his name, one of the judges. But that's his face. His cartoon face is on the wall. Also, we have a message from a viewer from Liberia.
Lucilia,
Sweet Gaia. Lucilia, Sweet Gaia. He said, my own country, Liberia, is about to go into election come October 10. I hope we don't have to go through this again. This too is Africa. Let's pray for our nations. Yes, Lucilia will be praying for Liberia. We know Liberia is also going through a lot there. The economy is not doing too well, and people are suffering. Africa needs to wake up. The continent that God endowed the most, but that is also the country that is going through more hardship, more suffering. The citizens are suffering. So that's why we here in Schengen story, we're not saying we should go to war or kill people and all that. We're saying maybe it's time to rearrange a new kind of engagement with our democracy. Maybe it's time to also look into how we go do business with our foreign investors, foreign partners, because Africa, so far, democracy has not helped Africa. So far, more people have suffered, more people are suffering. Children are languishing in malnutrition, kwashiorkor, sleeping, malaria, and dirty water, all these things. And it's sad. So, Lucilia, we were with you. Yes, we might even be covering the Liberian election live on this network. So be with us, Lucilia. So, George, what do you have to say before we go back to the courtroom, Abuja? What again do you have to say?
There is absolutely nothing to say. Like I said before we got started, if all things were equal, then we might be expecting something different. But what we know is just a process they're going through to seal, what has already been determined from the very beginning. So that's all they're doing. It's just a process. There is nothing new that we can gather out of this. It's just a process. They're going. That's why they decided to televise this to bore you with all the long conversation and everything else, as if all the cases that they are putting in the past, was judiciously done, and cases were determined judiciously. But it is not. They can put all these cases they're putting. It's just a way to go through that process and then end up with the same thing. Thousands of us have known that this is where they're going. So that's what we are seeing here.
So Christian is saying we must see the end today. Yes, Christian.
Well, I can Christian, I can tell you the end is already here. The end has been here from the very beginning. So that's what it is. So it's already been determined. They're just taking you through the tedious process, so that's all it is. What can you expect? Like I said before, it came to the point when I started hearing him and like, to your tents, oh Nigerians, the last department or that we thought might have at least done something a little different. They're hanging with the whole bunch. So that's where we are, and this is what it is. And it is sad. It is sad. People have lost again. Yes, they have lost again.
We will go back to the court with the words of Eddie. Eddie said it. He said the judge is reading as if he's trying to accuse the petitioners. And that's what it is, Eddie. In fact, the whole thing looks like it's been played out to make the petitioners look like they are the ones that are being judged, And
that's what it is.
Yes, it's sad. So we'll go back to Abuja. We'll go back to the courtroom. Let's just see it play out till the end. It's not sounding good, what we're hearing. It doesn't favor the majority, but what can we do? Let's continue. So, George.
It is not over until the fat lady sings. It's not over. They can bring this judgment here. That's how they decided to do in Niger Republic. That's how they wanted to do it in Gabon. But we saw what happened. It's not over yet. It's not over. Asari Dokubo can occupy Abuja if he wants to. And when the day of judgment comes, he will be one of those that will run away from Nigeria. Because people are tired. You can take it to the bank. You can take it to the bank. People are tired.
Thank you, George. So let's go to the courtroom and wind up with them. Thank you, George.
Doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and ordinary regulation guidelines for the conduct of election, the first respondent cannot be compelled to electronically transmit election results. The petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, in this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seemed to us that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of the petition, while specific allegations of corrupt practice were made in paragraph 60 to 78, even though them were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced below. I've produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. He further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. He also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. He also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the RF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the RF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25 February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IRF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the RF portal because it could not map the result uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs, indicating patches deployed to fix the error of technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the RF portal. The results are available as generated in their original form from the polling unit using the BVAS. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent, officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that the collation officer or return officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 64(4)(a), relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 44(b) of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, Subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64(5) that the collation officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or return officer will use to verify and collect the results, subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or return officer will use to determine the correctness of disputed result where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, subsection 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64, sub 4 of the Act, which requires only the counting and announcement of results of the polling unit. A careful examination of the above sections, slide opened by the petitioners, show that the Electoral Act had used the words deliver in Section 62, subsection 1, transfer in Section 60, subsection 5, and transmitted directly in Section 50, sub 2, 64, 4, 5, and 6 of the Electoral Act 2022, in stating how results of election should be handled under those provisions. A look at the definitions of those words in the Black's Law Dictionary 6th edition shows that the word transfer is defined at page 1497 as to convey or remove from one place person, etc., to another, or to pass or hand over from one to another, or to specifically to change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one stage to another until the results are finally collated and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1991 Constitution and Section 148 of the Electoral Act 2022 that the first one does annex herein made the regulations and guidelines for the conduct of elections 2022, as well as annex manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general election. The petitioners have also hinged their allegation of non-compliance on paragraph 38(1) and 2, 48A, D, C, 55 and 7 and 20, 51(2), 54(7), 55(7), and 93 regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive, get a copy of the guidelines you will see. Here we have produced it in this judgment. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates for their polling agents were available, such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system, in addition to the physical transfer of the election results to the registration area of ward collation officer. As stated earlier, the technological device as prescribed by ANIC in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38(2) and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANEC results viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit results and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANEC results viewing portal, IREF, is not a collation system. The Supreme Court in Oyetola and ANEC 2023, ANEC 23 LPELR, has explained the difference between the collation system and the IREF. In that case, IGIM JSC held as follows court. As their names depict, the collation system and the ANEC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides a relevant collation officer a means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the Annex Manual for Election Officials 2023 show that the Electoral Act provides in Section 62, subsection 1, that after recording an announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the Annex Manual, also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IRF will be used to collect results. The petitioners who contend that ANIC was mandatorily required to electronically transmit the election results to the colonial system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that ANIC was mandated to electronically transmit or transfer the results from the polling unit direct to the collation system as prescribed by ANIC. He stated that the IRF portal is part of the technological architecture developed or deployed by ANIC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the Beavers machine, and that his investigations and findings were on the ANIC IRF portal. He also agreed that it was only ANIC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine ANIC compliance with the Electoral Act 2022 and the ANIC regulations and guidelines for conduct of the elections 2022. He prevaricated under cross-examination by the first respondent when he first stated that ANIC at the IRF portal is an electronic collation system, but later recanted and said the IRF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to IRF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, our evidence was basically in respect of the health status of Amazon Web Services, which hosted the ANIC IRF portal. The testimony of PW8, the cybersecurity expert, also called by the petitioners, also related to the ANIC IRF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the Beavers machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that ANIC has not established any collation system to which results will be electronically transmitted from the polling units. Thus, his testimony on that fact remains unchallenged and uncontroverted. It is settled law that the court has a duty to act on unchallenged and uncontroverted evidence. The Bromwell Energy Trading Company Limited OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third respondents, had testified that the first respondent, through its chairman, made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by the first respondent, as such transmission was susceptible to hacking. The identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of Tribune newspapers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. Also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the annex chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the RF portal, none of the witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners that under the regulations, it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results. Paragraph 92 of the same regulations categorically provides that at every level of collation, where the annex copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulations provides that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of clause 93 of this regulation shall apply. The said clause 93 of the regulations, which I had earlier quoted, provides that where the annex hard copy of collected results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the RF portal to continue collation. And where none of this exists, the collation officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the annex regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collation of results. There is nothing in the Electoral Act or the annex regulations and guidelines to show that an electronic collation system was prescribed by the Commission, which results will be electronically transmitted. Thus, the petitioners were unable to establish the assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. The first respondent, on the other hand, has adduced unchallenged evidence that apart from the annex RF portal, no collation system was established by the first respondent to which the result of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results, and the electronic transmission to a collation system apparently introduced by the first respondent in the regulations and guidelines are not mandatory as contended by the petitioners herein. Also, my finding based on the evidence adduced that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the fiscal collection centers in the registration areas or ward collection centers, local government area collection centers, state collection centers, and the national collection centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the INEC result viewing portal, RF real time, the petitioners averred in paragraph 53, 97, and 98 the petition that the petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent, via a written communication, sought to excuse the manifest non-compliance with the requirements of the Electoral Act 2022 and the regulations by claiming that there were glitches in the electoral system which prevented it, that first respondent, from uploading the results of the presidential election from the polling units to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. The petitioner shall contend that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to credit unlawful votes to the second respondent and thereby wipe out a clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent averred in paragraph 59, 55, 7, 8, 9, and 10 of their reply to the petition that I will produce them here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server's contents of the IRF hosted on the AWS cloud platform to show that the results of the election were uploaded on the IRF portal, but the first respondent attempted to delete or remove the uploaded results. It is true that a petitioner who alleges non-compliance with the Electoral Act has the legal burden to establish that non-compliance and show how the non-compliance substantially affected the result of the election. Ladoja and Ajimobi, Shinkafi, and Yari improve of their assertion. The petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not founded along with the petition, as mandatorily required by paragraph 45 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I had upheld the respondent's objection and struck out the evidence which include their witness statements on oath and the documents and or reports tendered there through them. These are exhibits PCJ-A to F, PCJ-4, 6 reports of AWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7 and PW8 and the other witnesses called by the petitioners. PW7 claimed to be a cloud engineer or architect, an employee of Amazon Web Services. She stated that she is not only a member of the Labour Party, the petitioner is herein, but she contested election as a candidate for member House of Representatives for Ogoja, Rogyala, Federal Constituency of Cross River State. He stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Collation centers and design, yes. development from implementation, testing the code, staging the software and development and deployment. She stated that she was aware that at the process of testing and staging of software code and problems or challenges, any problems or challenges with the software will usually show and or be flagged. He stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying the software. He stated that if a software from application has any glitch, such a glitch will pop up that is flagged at the testing stage. He stated that from her preliminary review of the public viewing facing the RF website, she is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. He stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA for S3 service, it is designed to provide 99.999% durability and 99.99% availability of objects stored over a year. He said this is accessible to the public on http://docs.aws.amazon.com, Amazon S3 latest user guides from data durability.html. He stated that the AWS code servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.aws.amazon.com from health/status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. It stated that from the post-event summary by AWS, the last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues affecting only one region. He said this is available to the public. AWS7 stated that she was aware that a glitch in the software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software, change its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed production maintenance, which is an important element of software development lifecycle. He denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. He stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. He admitted that the AWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. He admitted that the report that only shows the health status of all AWS services in all regions in terms of the infrastructure and not security. He admitted that in order to know what happened on applications deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. PW7 also stated that she is familiar with AWS CloudTrail, and there is a CloudTrail for every AWS account and for every API action made on that account. She admitted that she did not produce the CloudTrail for any deployed application before the court. He denied that the CloudTrail is the best account of what transpired on any deployed application, but did not state the best way to know what transpired. He stated that it is highly unusual for glitches to occur for primary functions of applications in production, She stated that she was not aware that glitches happened with the Central Bank of Nigeria e-money project, or the one that happened with the MTN Mono PSG. She admitted that she was a candidate for the Labour Party at the last election. She also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on course examination by the second and third respondents, PW7 admitted that exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. She also admitted that she had been attending the court and watching the proceedings before the day of her testimony. She admitted that the report she presented before the court is public information posted by Amazon, and that it is available and accessible to the public. She, however, insisted that the report is hers because she was the one who downloaded it, brought them to the court. PW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against ANIC because she was not placed on the final list of candidates published by ANIC. She admitted that her complaint was because she tried several times to upload her information on ANIC's site, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application, even as she disagreed that there was a glitch on ANIC's site. She admitted that in her affidavit. She stated that ANIC's site crashed. PW7 also stated that she was aware that EWS experienced outage of several hours on Tuesday, 28 February 2017, and that as at 2021, AWS also was reported to have suffered more than 27 outages. She also admitted that what was sent to RF was the image of the form EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocol to modify the applications of ANIC. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. However, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was December 2021. As to whether glitches can happen again, she stated that anything is possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the ANIC regulations and guidelines for the conduct of elections 22 and the ANIC Manual for Election Officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the beavers to RF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed for production. On cross-examination by the first respondent, PW8 stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On 17th and 18th March 2023 and concluded the final report at the end of May 2023. PW8 stated in paragraph 14 of this his adopted written witness statement that He read the petition, and the first respondent replied to the petition in doing his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units to establish that it is possible to show metadata. He stated that there were errors in those polling units, and he did not have to examine the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the CloudTrail and confirmed that the CloudTrail will explain the availability of the application of INEC on the AWS infrastructure. PWA, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of Exhibit PCK2 and stated that it means an electronic collation system. When cross-examined by second and third respondents, PWA denied that it was part of his brief to assist the Labour Party to respond to the respondent's reply. He admitted that he did not inspect any of the beavers' machines and did not interrogate Festus Okoye, whose statements he referred to. He confirmed that Exhibit A, which he attached to his report, is the metadata of 23 pages showing multiple uploads. He denied that it contains information which are coded and not explained, and insisted that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report that stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by the first respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IRF, and he did not interact with the presiding officers of those polling units and did not see the hard copies of those results. He could not also tell whether those results have been collected. Starting with the evidence of PW7, is evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she had been attending court and watching the proceedings prior to making her statement on oath and testifying as a witness. Her testimony, therefore, was essentially a demonstration of her support and loyalty to the second petitioner. Her claim to being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a worthless paper. It has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not in terms of security. She had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded. And her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responder's application posted on the AWS is not before the court. Her conclusion on the totality of this witness is that it is devoid of any probative value. As for PWA, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collation centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collation centers. The petitioners have left no evidence to establish the existence of any collation center to which the potential election results were to be electronically transmitted for collation. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the RF portal real time on 25th February 2023 was due to a technical glitch experienced on their e-transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent that polling unit results being uploaded to the annex e-transmit system by the presiding officers were pushed to the Senate and House of Representatives modules on the IREF, but the results of the presidential election were not being pushed to the presidential model on the IREF. That based on threat levels and reports of security agencies that the first responder servers may be subjected to attacks on election day, the first responder first course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack, but the issue was a HTTP 500 error from which the application, within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly. That a thorough investigation revealed that the e-transmission was unable to map the uploaded results of the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure to organize the uploaded results in the hierarchy of election, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system. And that the old system randomly saved uploaded results by timestamps, making it difficult to upload results sheets by election or by state. He stated that the deficiency was observed after the Ocean State Governorship election 2022. RW1 stated that during the election of 25th February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies to their respective states. And that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy for the results organization. But for the presidential election, the application crashed because the presidential election does not belong to any state on the first respondents database. And any attempt by the application to build a folder structure to organize the election results failed with a HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. He stated that the first presidential election results was successfully uploaded at 8:55 p.m. on the 25th February 2023. He further stated that to confirm that the glitch actually happened, as well as the time that all patches to fix the error were created and deployed, can be viewed on AWS Cloud Trail and AWS functionality that allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the Cloud Trail logs. He stated that the technological glitch experienced on the e-transmission system was not a ploy to manipulate the election, and the glitch did not affect the results of the election. He then tendered RA6 and RA7, the Cloud Trail log, and his certificate of compliance with Section 84 of the Evidence Act 2011, and identified same as the documents he referred to in his witness statement on oath. Under cross-examination by the petitioners, RW1 confirmed that testing was carried out on the e-transmission system, the first respondent, on the 4th February 2023, before it was deployed and a report was issued. When shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. The petitioners then tendered the report of vulnerability assessment and penetration testing through its witness, which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, the burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2011. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. The first respondent, on the other hand, has offered credible evidence in the form of Exhibits RA6 and RA7 to show that its e-transmission application posted on the Amazon Web Services, which is supposed to upload the results of the presidential election to the RF, has suffered a glitch on the election day on 26 February 2023. On the preponderance of evidence, I am convinced that the petitioners have failed to establish their assertion that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC Manual for Election Officials 2023. By Section 134, subsection 2 of the Electoral Act 2022, only an act or omission which is contrary to the Electoral Act 2022 can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints for questioning an election. In interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134.2 of the Electoral Act 2022, the Supreme Court held in Newsom and Peterside as follows. Quote, the above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections by Section 138.2 of the Act, so long as an act or omission regarding such regulation or guideline is not contrary to the provisions of the Act itself, it is not of itself a ground for questioning the election. See also JGD and INEC. Since, as shown above, the electronic transmission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the regulations and guidelines for conduct of elections 2022 and INEC Manual for Election Officials 2023, the failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1B of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received, reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC 8B1, in respect of the states where the second respondent duly won the election, as shown in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that it duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1, as alleged by the petitioners. It was the subordinate senior counsel that with regard to the state of the pleadings and the issues of fact in contention. The onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73, Subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. It relied on the decision of this court in First Bank Nigeria PLC, Adjacent Business Investments, and Royal United Nigeria Sterling Bank PLC, submitted that the first respondent did not lead any evidence in proof of their positive assertion there was compliance with the state provision of Section 73, Subsection 2 of the Electoral Act. Learned Counsel submitted that on the part of the petitioners, they have led evidence through PW12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as exhibits PCQ1 to PCQ6. He added that the petitioners have also served subpoena duces tecum on the first respondent to produce the said forms, but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the forms. Counsel asked the court to invoke the provision of Section 167E of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with Section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno, Ekiti, Gawa, Kogi, Kwara, Niger, Ogun, Ondo, Oyo, Rivers of Zamfara states, which are shown in the form EC8DA, admitted in evidence as exhibit EBF. He pointed out that Section 135, Section 1 of the Electoral Act 2022 only deals with non-compliance generally, but Section 73, Subsection 2 of the Act has provided a specific effect of non-compliance with provisions, relying on Crown's Townsend Organization for the National Institute of Policy and Strategic Studies, He urged the court to hold that substantial non-compliance has been established by petitioners. Arguing per contra, learned senior counsel for the first respondent referred the court to section 135(1) of the Electoral Act 2022 and submitted that the petitioner complaint of non-utilization of prescribed forms, even though not proved, cannot without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude section 73 of section 2 of the Act from the ambit of section 135, section 1 is a non-starter because the non-compliance referred to in section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved such non-compliance nor shown that it has substantially affected the result of the potential presidential election. I urge the court to so hold. Petitioner had contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging the negative, and as such, the burden is on the first respondent to establish that they have duly complied with the provisions of section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Aviation Business Investment Limited, Royal United Nigeria versus Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Anik, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation rests on him, loss of court. Again, this court in Dashi and others versus Druven and others espoused this legal position when Ugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. But while it is true that the burden of proof is generally on the person who substantially affirms the positive of an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ, Abra was a Northeast Railway Company, 11 Queens Bend Division 440 at 457, when he said that, quote, in an action for malicious prosecution, a plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense, that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are, after all, relative and not absolute, loss of court. In the instant case, the petitioners have made their allegation of non-compliance with Section 73(2) of the Electoral Act 2022 by the first respondent as an essential part of their case in challenging the results of the election declared by the first respondent. Not only are the petitioners statutorily required by Section 135, subsection 1 of the Electoral Act to establish substantial non-compliance with the provisions of the Act, they are required to show how such non-compliance has substantially affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election. It encompasses non-compliance with all provisions of the Electoral Act, including Section 73, subsection 2 thereof. In other words, Section 73, sub 2 is not derogated from the ambit of Section 135, Section 1 of the Act. Indeed, in Buhari and Anik, Toby Joy is while considering considering Section 145(1) of the old Electoral Act, similar to Section 135(1) of the External Electoral Act 2022, had held at page 48, paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1) of the Act, the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73 of Section 1 up to, as part of their course of action, have the burden to establish that non-compliance in accordance with the requirements of Section 135(1) of the Act. The petitioners have also relied on the evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits are acknowledged copies of letters dated 6 March 2023, 14 March 2023, 10 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman or the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioner also relied on subpoena duces tecum served on the first respondent to produce the said form. In his testimony at paragraph 58 to 60 of his adopted written statement on oath, PW12 merely stated that the petitioners made several applications through his campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30th May 2023 and 13th June 2023 were issued on the chairman of the first respondent to produce some documents. The record also shows that on the 20th June 2023, one Olufinmilayo Taiwo, the Deputy Director of Certification on Complaints and Legal Drafting with ANIC, appeared on behalf of the first respondent in answer to the subpoena duces tecum. While she produced some of the documents required of the first respondent in the subpoenas, he informed the court that the documents listed in the subpoenas as listed E, C, D, and E are in the states. And since the subpoena was served on them just before the previous day, it will take some time for the first respondent to get them. An examination of exhibits PCQ to PCQ6, which were tendered by the petitioners through PW12, showed that all except exhibit PCQ are letters addressed to the chairman or the first respondent by the petitioners and their solicitors requesting for inspection of documents and for certified copies of those documents. Exhibit PCQ4 is a covering letter addressed to the resident electoral commissioner, Benue State, from the law firm of Dr. Panyechi Piazzo, SAN and Co., notifying the respondent, the resident electoral commissioner, of subsequent action on the solicited letter by the National Chairman, ANIC Headquarters, Abuja, dated 6 March 2023. It is instructive to observe that Section 74(1) of the Electoral Act 2023 mandates the resident electoral commissioner in a state where an election is conducted within 14 days after an application is made to him by any of the parties to an election petition, cause a certified true copy of such document to be issued to the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits an offense and is liable on conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 so that they were all addressed to the chairman of ANIC instead of the resident electoral commissioners in the states, as required by the petitioners section 74, subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures of requesting for those documents. More so, when the record shows that the subpoenas, which they claim to have served upon the first respondent, were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 had stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, he stated that he was neither a polling agent nor a collation agent. His evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with section 73(2) of the Electoral Act. The Electoral Act 2022. Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to comply with the provisions of section 73, subsection 2 of the Electoral Act 2022. Rather, PW10 gave us here the supervisory presiding officer for Madagali Ward in Adamawa State, who was subpoenaed by the petitioner to testify on their behalf, as stated in paragraphs 4 and 5 of his witness statement oath, that as a presiding officer, he reported to the local government area INEC offices in Gulam, Madagali local government area in Adamawa State, on the 24th February 2023 to collect the sensitive and non-sensitive materials for the 25th February presidential election and National Assembly elections, and that after collecting the materials, he proceeded together with security agents and other INEC officials, which consisted of presiding officers, assistant presiding officers 1, assistant presiding officer 2, and assistant presiding officer 3 to Madagali Ward that evening to the registration area. His evidence was also to the effect that on the day of the elections, everything went well, and after sorting and counting the votes, the presiding officer did the entry and snapped the results to Beavers for the upload and transmission of the results to the INEC portal, but were unable to upload. And when they complained to him, he requested them to come to the registration area. It is therefore clear from the above that the petitioners were unable to establish the allegation of non-compliance by INEC with section 73(2) of the Electoral Act 2023. The evidence PW2 and exhibits PCQ1 to PCQ6 have not been able to rebut the presumption of regularity, which inures to the first respondent under the law, which can only be rebutted with cogent and credible evidence, EAPC and Sheriff, others. From the totality of the evidence adduced on this issue, I'm of the considered view that petitioners have failed to prove substantial non-compliance with the provisions of the Electoral Act 2022. 2 is therefore resolved against the petitioners and in favor of the respondent. Issue 3 is whether from the totality of the evidence, the petitioners have proved that the presidential election held on 25th February was invalid by reason of corrupt practices. Here again, we have considered the submissions of counsel. So in their petition, the petitioner made allegations of suppression of scores, unlawful reduction, and inflation of results, uploading of fictitious results, misrepresentation and manipulation of results where no election took place, overvoting, and wrong computation of results. These allegations are contained in paragraph 60, 78 for the petition. In paragraph 60, 61, 62, 64, 65, 68, and 69 of the petition, the petitioners allege that due to the first respondent's refusal and neglect to upload and transmit the result of the election to the IRF on the day of the election, the first respondent suppressed the actual scores obtained by the petitioners. According to them, the suppression of the first respondent scores, which occurred in 18,088 polling units, was orchestrated by the first respondent, deliberately uploading readable and blurred forms EC8S on the IRF, and thereby suppressed the lawful scores obtained by the petitioners in the said polling units. They further alleged that in Rivers State, during the collation exercise, the first respondent announced scores of the petitioners as 175,071 votes, and the second and third respondents as having 231,591 votes, when in actual fact, the petitioners' lawful votes are 205,110, while that of the second and third respondents ought to be 84,108. They similarly allege that in Benue State, the first respondent suppressed the lawful votes obtained by the petitioners when it announced their votes as 308,372, and that of the second and fourth respondents as 310,408, when the actual votes of the petitioners were 329,000, and that of the second and third respondents at 300,421. The petitioners also alleged that the first respondent was purporting to upload the result of the presidential election on the IRF, embarked on massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, as well as uploading incorrect results. They stated that if the results of polling units, votes, local government states are properly tabulated and calculated as required by the Electoral Act and the regulation and guidelines for the election, the overall results of the election and the percentages scored by the political parties will show that the petitioners won the presidential election of 25th February 2023. They stated that the petitioners should rely on a report of inspection of the electoral materials. In the earlier ruling of this court on the preliminary objections raised by the respondents on the propriety of the averments contained in the petition, we held that apart from the allegations of inflation and reduction of votes in Rivers and Benue states, where the petitioners have stated the figures alleged to be inflated and reduced, the other allegations of the petitioners were nebulous and bereft of the material particulars. We held that the said averments contain no particulars of the polling units where the alleged infractions took place, or the figures alleged to have been inflated or reduced. We had struck out those paragraphs for offending paragraph 41D2 of the first schedule to the Electoral Act 2022. Indeed, apart from the strict requirement of stating material particulars in election petitions, it is also tried that in civil litigation, including election petitions, whenever fraud or any other crime is alleged, material facts of such allegation of fraud or other crime must be pleaded and clearly set out. See Omo Borio and others was adjusting, Yeso Limited and Honey Legion, Lorin and others versus Sangolana, others. The petition allegations of suppression of votes, inflation and reduction of votes, massive misrepresentation and manipulation by uploading fictitious results all amount to falsification of results of an election. This versus Ukur. The Supreme Court held that allegations of inflation with non-existing votes is another way of alleging falsification of results. Indeed, in Haruna and Modibo, the Supreme Court held that where a petition is based on allegation of incidents of fraudulent acts, manipulation of results, or falsification of results, that allegation is criminal in nature, and evidence required in proof thereof must be clear and unambiguous. In other words, the proof must be beyond reasonable doubt. This section 135 sub 1 of the Evidence Act and cases of Buhari and Obasanjo, Emmanuel Umana, Ipiazu, Oti, Abubakar, and others for Yaradua, Omishore, Ali Bashola, Magaji, and All Progressive Congress. In order to establish falsification of election results, the petitioner must produce in evidence two sets of results, one genuine and the other false. In the cases of Kaki and PDP, Mobodo and Ono, Adewale and Olaifa. See also Chima Anoze versus Dr. Ken Obichere and others. And Joseph Olujimi Kolawole Abaje versus Babatunde Raji Fashola. The Okichiku and another versus Onyebu. To prove their petition, the petitioner also, who indicated during pre-hearing, they will call 50 witnesses, call only 13 witnesses. They are mentioned here. Of the above 13 witnesses, only 3 had their witness statements on oath filed along with the petition. These are PW1, PW2, and PW12. In our ruling on the respondent's objection to the competence of the petition witnesses at the beginning of this judgment, we had struck out the evidence of PW 3, 4, 5, 6, 7, 8, 9, 10, 11, and 13 on the ground that their witness statements on oath were not filed along with the petition as mandatorily required by paragraph 45B of the first schedule to the Electoral Act. However, even if the statements of those witnesses of the petition were to be considered, the question is, are those testimonies cogent and credible to establish the petitioner's allegations stated above? PW1's testimony was only on the alleged double nomination of the third respondent and Pecho proceeding, which we have already determined above. Even as he stated that he voted in his polling unit during the election, he stated that he did not play any other role in the election beyond exercising his civic responsibility. As for PW2, who said he was a software engineer, he stated that upon his reading of the relevant provisions of the Electoral Act and annual regulations, he is aware that the presiding officer in the polling unit is mandated to electronically transmit or transfer the result of the election direct to the polling to the collation system as prescribed by ANEC, and to also use the beavers to upload a scanned copy of the polling unit result sheet to the ANEC result viewing portal prescribed by ANEC. He said, from his knowledge of software engineering and computer operations, RF is a server and is accessible to the public. He said he was aware that the information or data generated or inputted in the beavers were operating online or offline, were transmitted to the ANEC servers, including virtual servers hosted on AWS cloud. On cross-examination with first respondent, however, the witness admitted that his opinion was based purely on his reading of the Electoral Act and ANEC guidelines, and that he was not familiar with the applications and operations of the beavers machine. He stated that he did not play any role in the election. Indeed, as admitted by the witness, the statement, particularly paragraph 10 to 13, is a virtual reproduction of Section 38 of the Electoral Act 2022. On cross-examination by the fourth respondent, he admitted that he did not state his educational or professional qualification or experience in his statement on oath. He also stated that his investigation was based on publicly available application program interface, API, and collected information through it, like from EC8S. He said he did not have the documents and forms he used, and that everything was in laptop. Contrary to the speculation of the petitioners that ANEC was not prepared to conduct the promised credible, authentic, and transmitted election, or that it deliberately or mischievously allowed the compromised IT infrastructure to be deployed for the conduct of the presidential election, PW2 confirmed that Amazon Web Services is the most secure service providers in the world, and that it is used by corporations, companies, individuals, and governments that are most concerned with security. In his entire evidence, PW2 did not talk about the contents of any result, Instead of supporting the petitioner's allegations, the evidence of this witness supports the case of the first respondent. As for PW3, PW5, and PW6, he merely tendered flash drives containing speeches of the ANIC chairman, Mahmoud Yakubu, and ANIC National Commissioner, Festus Okoye, wherein they gave assurances that results of the election will be transmitted to the RF for public viewing. Being mere assurances, the evidence of these witnesses had no utilitarian value in establishing allegation of corrupt practices made by the petitioners in this case. In his evidence, PW4 tendered exhibits PZD 1, 2, and 3, which he claimed to be the report of his analysis of the presidential election. The witness also tendered 4 boxes containing what he called 18,088 blood polling unit results downloaded from the RF portal, which were also admitted as exhibits PCE1 to PCE4. However, in the earlier ruling of this court on the respondent objection, we have struck out exhibits PCD 1, 2, 3, as well as exhibits PCE 1 to 4, along with the witness statement on oath of PW4, which was not filed along with the petition since the documents were tendered through the incompetent witness. The witness claimed in his evidence that from his investigations, the scores on forms EC8S of 39,556 polling units were inaccessible as they contain uploads not connected with presidential election, and that the number of accredited voters affected by the 18,088 blood result was 2,565,269, while the number of voters who collected their PVCs was 9,165,191. According to him, this signified that the votes of 5,533,553 accredited voters were discountenanced by the first respondent. He added that 23,119,298 registered voters collected their PVCs in those 39,546 polling units, and concluded that both the number of accredited voters of 5,553,553 and number of voters who collected their PVCs of 23 million plus polling units far exceeded the margin of lead from the first respondents' announced result of 1,807,206 over the first runner-up and 2,693,193 over the second runner-up. PW4 also stated that in Benue State, neither the results he obtained from the RF nor the CTCs of forms EC8S matched the results of the first respondent. He stated that the annex CTCs of forms EC8S showed that LP got 272,468 votes and APC got 256,852 votes, while the results from the RF portal showed that LP got 260,796 votes, while APC got 268,630 votes. He added that the ANEC announced result showed that LP got 308,372 votes and APC got 310,468 votes. He concluded that by adding uncovered votes and deducting votes affected by overvoting, manipulation, alteration in Benue State, LP got 281,426 votes, while APC got 258,683 votes. A look at the 18,088 blood polling unit results, which the witness claimed to have downloaded from the RF portal, showed that they were not certified by the first respondent. Being secondary evidence of public documents, they are clearly inadmissible. See Section 89E and 90E of the Evidence Act 2011, case of Emeka versus Ipiazu, others. Of note is that PW4 admitted under cross-examination by first respondent that the primary source of the data he used in his investigation is from the RF portal. This clearly means that he based his investigation on inauthentic data, since the essence of certification of public document is to ensure authenticity of public documents. See the cases of Ebwe and Araka and Emmanuel Basuma. Also under cross-examination, PW4 stated that his reference to Form EC8A and the result on IREF portal are not the same thing, and that Form EC8A is a paper, while the result on IREF is a copy of it. He particularly admitted that by his reference to blood Form EC8As on the IREF, he was not suggesting that the hard copies of Form EC8As are also blood. This admission by PW4 also dealt a death nail to the allegation made by the petitioners in paragraph 60 of the petition that the first respondent suppressed the first respondent's cause to 18,088 polling units by deliberately uploading unreadable and blood forms EC8As on the IREF. In fact, PW4 had under cross-examination completely rubbished his own report when he admitted that the IREF portal is not capable of collating and tabulating the election results, and that it is the image of the Form EC8A that is transmitted to IREF, while the hard copy of Form EC8A is taken to the collation center, which he stated is collected at what local government, state, and national collation centers. He also admitted that since the result in the Form EC8A is taken to the collation centers, the failure to transmit its image in IREF or that image transmitted its blood will not change the result already entered in Form EC8A. Again, the witness admitted under cross-examination that his report in exhibits PCD1, PC2, and PCD3 only covered the two states of Rivers and Benue, and that he worked on only available data, that if he had more data in his report, it would have been different. He further admitted that his report, exhibits PCD1, 2, and 3, is not a product of expertise, as any secondary school student can do the simple arithmetic involved in it. This admission by PW4 effectively rubbishes his entire report as inconclusive and manifestly unreliable. In the whole, the evidence of this witness, even if it were to be considered void of any probative value. As for the evidence of PW7, we had earlier analyzed and evaluated her testimony and found that she was not only a person interested in this petition. The report in exhibit PCJ3A, which she brought to the court purportedly as an expert witness, was merely downloaded by her from AWS site, which was openly accessible to the public. Her evidence is also of no probative value. With regard to the evidence of PW8, I have earlier analyzed and evaluated his evidence while resolving issue 2. Suffice it for me to state that I had found that PW8, having admitted that in the course of his commission to work, he had read the petition and the first respondent's reply, as well as the Electoral Act and annual regulations and manual, and that he finished his final report in May 2022 during the hearing of his petition. PW8 had practically worked to a predetermined answer, and his evidence was of no probative value. PW9, who gave evidence as an accredited observer of the election, had stated that everything about the election in the polling unit, which he observed went as accreditation and voting took place. The votes were counted and the results were announced and recorded on Form EC8A, but was not uploaded on the IREF at the polling unit. Under cross-examination by the respondents, he stated that from his observation, the election went on smoothly in his polling unit and that the election officials complied with the annual regulations. He stated that the result was taken to the collation center by the election officials. Rather than support the petitioner's case, the evidence of this witness actually reinforced the response case that the election was conducted in substantial compliance with the Electoral Act and annual regulations guidelines. PW10 stated that he acted as an ad hoc supervisory presiding officer for Madagali Ward, and that on election day, he collected the materials with security agents and other annual ad hoc presiding officers. He stated that voting went on well until 6:30 p.m., and all voters who were on queue by 2 p.m. duly voted at Unit 004, DISA. He stated that after sorting and counting of the votes, the presiding officers did the entry and snapped the results with the beavers, but were unable to transmit and upload same to the IREF portal. after the result of the National Assembly election was uploaded. He stated that when the presiding officers complained to him, he asked them to come to the registration area, where he requested them to meet the registration area center tech, who asked them to submit the beavers to him for transmission, but was unable to upload. On cross-examination by the First Respondent Council, PWA stated that apart from the small issue between agents of APC and PDP, which was satisfactorily resolved, everything went well, and the results were entered in Form EC8S in the units and were properly announced. And added that the physical copies of the Form EC8S were taken to the Ward Collation Center. Cross-examination by second and third respondents, the witnesses have confirmed that notwithstanding the difficulty in uploading the results, the collation of Forms EC8A took place in the ward. The evidence of this witness also supports the case of the respondents rather than of the petitioners. PW's 11, head of the Legal Services National Information Technology Development Center, NIDA, merely stated that he was subpoenaed, produced, and tendered the following documents. A, correspondence of documents, letters, emails sent by him, sent by or from Independent National Electoral Commission, the National Information Technology Development Agency, requesting for the IT clearance approval of the IT infrastructure to be deployed and or deployed by ANIC for the conduct of 2023 general election. B, the certificate of clearance approval issued by NIDA to ANIC pursuant to any request in A above. C, the report submitted by ANIC to NIDA containing certification for the testing review of the IT infrastructure deployed for the conduct of the 2023 general election. Stated that they don't have any of the documents in their office. Under cross-examination by the second and third respondents, he stated that the NIDA Act does not contain cybersecurity standards. He also stated under cross-examination by the fourth respondent that their supervisory ministry is Ministry of Communication and Digital Economy, and that the minister stated that there were 16 million attempts to hack the INEC IT infrastructure on the day of the election. The evidence of this witness is of no assistance to the petitioners. PW12, the petitioner's star witness, whose evidence was merely a copy of the averments in the petition, stated that on the day of the election, he voted at his polling unit at Dawaki, Abuja, after which he went to the situation room of his party. The second petitioner, he stated that apart from his polling unit and the situation room, he was not present physically at any other place on the day of the election. He stated that he was not a collation agent or polling agent in any polling unit or collation center. His evidence in chief was therefore mostly laced with hearsay, settled that hearsay evidence inadmissible and has no probative value. Apart from his evidence in chief being inadmissible hearsay, Exhibit X1, a certified true copy of the judgment of Federal Court, Abuja, suit number FHC ABGCS 1454-2022, was tendered through him under cross-examination by the first respondent, and he read out a portion of the judgment of the court, which was to the effect that the first respondent was under no mandatory obligation to electronically transmit or collect results of the election. He also admitted that he did not state in his statement on oath any figure unlawfully ascribed to the second respondent and third respondent by the first respondent. He also stated that his party had agents throughout the federation with over 133,000 votes. When asked by the second and third respondents council to state the score of the of the Labour Party, the witness stated that he will not know scores of the Labour Party because the results are being uploaded on the IREF. He added that he will not know the unlawful votes accredited because he is not an expert, and that the wasted votes are part of the statement made by the expert. When cross-examined by the fourth respondent, PW12 said he was not aware that ANEC chairman had given a statement that ANEC will not transmit results electronically. When confronted by the fourth respondents council, he confirmed that his statement on oath wherein he stated that he will rely on the evidence of forensic experts was made on 20th March 2023, while the final expert report he was relying on was made in May 2023. clear that PW12 should relied on an expert report that was not in existence at the time he made his statement. Obvious that the evidence of this witness lacks credibility and is therefore manifestly unreliable. PW13 was the only presiding officer called by the petitioners in this petition. His evidence was that in his polling unit 035 at open field Ward 04, Ikun local government area in Kaduna State, the election went well, and that thereafter all efforts to upload the presidential election results as captured in Form EC8A failed except the National Assembly results. That when all efforts failed, he proceeded to the collation center with other ad hoc staff. When cross-examined by First Respondents Council, he stated that he recorded the results manually, and the only problem he had that day was the uploading of the result. That when he could not upload the result, he called his supervising officer, who told him to take the result to the Ward Collation Center, which he did. On cross-examination by Second and Third Respondent Council, he confirmed that after recording the results manually, he signed and the party agents also signed. When cross-examined by the fourth respondent, he stated that after signing the result, he gave copies to party agents. The evidence of this witness actually supports the case of the respondents that the election was conducted in substantial compliance with the Electoral Act 2022. In Buhari and INEC and others, the Supreme Court clearly stated law as follows. Quote, a petitioner who contests the legality or lawfulness of votes cast in an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the legality or unlawfulness of the votes cast and prove that the illegality or unlawfulness substantially affected the result of the election. The documents are amongst those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of the election, not those who picked the evidence from an eyewitness. No, they must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of the votes cast and the subsequent result of the election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only the documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities both in the conduct of the election and the recording of the votes. Wrongdoings and irregularities which affected substantial result of the election. Proving an election petition or proof of election petition is not as easy as the Englishman finding coffee on his breakfast table and sipping it with pleasure, particularly in the light of Section 146(1) of the Electoral Act. The petitioner has a difficult, though not impossible task, close of court. See Mohammed and another for Stanley and others. In this petition, where the petitioners have labeled several allegations against the first respondent, such as suppression of votes, lawful reduction and inflation of results, uploading of fictitious results, misrepresentation, manipulation of results where no election took place, and wrong computation of results, it is evident from the above that the petitioners have not laid any credible evidence to substantiate those allegations. Of the 13 witnesses they called, only 2 are presiding officers who were present at the polling, who are present at their polling units. Hence, the petitioners have not been able to establish any of those practices which they allege. The evidence of the witnesses which the petitioners call as experts to try to establish that the first respondent is mandatorily required to transmit election results for the purpose of collation or to link the delay in the upload of the presidential election results to average by the first respondent. Any of the malpractices which they allege are devoid of any value. The petition allegations have remained mere speculations and unfounded accusations. The petitioners have failed to establish beyond reasonable doubt the corrupt practices which they allege as required of them under Section 135(1) of the Evidence Act 2011. On the petitioner's allegation of overvoting, Learned Counsel for Defense Respondent contended that to prove overvoting, the direct record of accredited voters and the beavers machines are required alongside the voters register of the affected polling unit. He pointed out that the petitioners failed to produce the beavers machines and the voters register. He submitted that the petitioners want this court to rely only on the expert opinion of PW4, which is not credible. He submitted that when PW4 was confronted with the results in polling unit 002 of Ward 7 of Degema, LGA, River State, which was part of his report on overvoting. In exhibit PCD2, he stated that there was no overvoting, as the number of votes cast was 40, while the number of accredited voters was also 40. He relied on Oetola and INEC at this court to discountenance PW4's evidence of voting. The petitioner's allegation of overvoting is contained in paragraph 72, 76, and 77 of the petition, which have been produced here. In the earlier ruling of this court, the respondents' various preliminary objections to the competence of the above affirmed petitioner's allegation of overvoting were upheld, and the court had struck out the said paragraphs for being vague, nebulous, and imprecise, having failed to disclose the specific polling units in the state where the overvoting is alleged to have occurred, the number of votes affected, the alleged margin of lead, etc. Indeed, in that ruling, we had observed that the forensic report containing the details of the polling units and other information which the petition said they have incorporated to the pleading by reference were not filed along with the petition as to be part of the pleadings. Proof of their above allegation of voting, however, the petitioners solely relied on the evidence of PW4, the subpoenaed expert witness, as well as the forensic report made by him, which is contained in Exhibit PCD 1, 2, and 3. Exhibit PW4's evidence was basically that from his investigation in Exhibit PCD 1, 2, and 3, he discovered that there was overvoting in 4,407 some polling units, which affected 2,317,129 voters who had collected their PVCs. He stated that this also exceeds the margin of lead of 1,807,206 over the first runner-up. He also stated that from his analysis of River State results, the first respondent announced results which were inconsistent with those uploaded on the RF portal. PW4 also stated that from the Forms EC8S downloaded from the RF portal, there is evidence of manipulations and alterations in favor of APC and against the Labour Party LP. He stated from the results on the RF portal, LP got 208,564 votes, while APC got 118,999 votes in River State, as against 175,071 votes for LP and 231,591 votes for APC. He concluded that when the unlawful votes are deducted, it will amount to 205,110 votes for LP and 84,108 votes for APC. In the ruling on objections to witnesses and documents made in the earlier part of this judgment, the witnesses stated on oath, the witness statement on oath of PW4 was one of those struck out for offending paragraph 45B of the first schedule to electoral 2022, them not having been filed along with the petition. With the statement of PW4 struck out for being incompetent, exhibits PCD 1, 2, and 3, the forensic report tendered by him, were also struck out for being inadmissible. As stated earlier, the oral evidence of PW4 contained in his witness statement on oath and his report in exhibit PCD 1, 2, and 3 are the only evidence adduced by the petitioners to establish their allegation of overvoting. With the witness statement on oath of PW4 having been struck out for being incompetent, and the forensic report in exhibits PCD 2, 1, 2, and 3 also struck out for being inadmissible, there was no other evidence to substantiate the petitioner's allegation of overvoting. The petitioners have therefore failed to prove their allegation of overvoting. Issue 3 is also resolved against the petitioners. So based on the Based on all the foregoing, it is evident that the petitioners have failed to establish their allegations of corrupt practices and overvoting. In consequence, issue 3 is also resolved against the petitioners and favor of the respondents. But issue 4 is whether from the evidence adduced by the petitioners, the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. This issue deals with section 134, subsection 2 of the Constitution, the issue of 25% votes, Abuja. Whatever it is. What did Well, the resolution of this issue basically borders on the interpretation of section 134, subsection 2B of the 1999 Constitution. The appropriate starting point for the resolution of this issue, therefore, is to reproduce, for ease of reference, section 134(2)A and B of the Constitution of the Federal Republic of Nigeria, 1999, as amended, the interpretation of which is in contention. It reads thus. A candidate for an election to the office of president shall be deemed to have been duly elected, where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation, in the Federal Capital Territory. The contention is as to the interpretation to be accorded to paragraph B of subsection 2 of section 134 quoted above. In particular, the contention is whether or not, by the wordings in that paragraph, a candidate must, in addition to scoring not less than 1/4 of the votes cast in at least 2/3 of the states in the Federation, also score 1/4 of the votes cast in the Federal Capital Territory, Abuja, before he can be deemed to have been duly elected. In other words, whether in determining 2/3 of the states of the Federation in the Federal Capital is to be included and regarded as one of the states of the Federation, or his status is to be regarded as distinct from the other states of the Federation, such that scoring 1/4 of votes in the FCC is a mandatory requirement for a candidate to be deemed duly elected as president. It is pertinent to state that unlike interpretation of statutes, the interpretation of the Constitution has its own guiding principle. We'll look at the principles as stated in Federal Republic of Nigeria versus Ganjua, reported in the electoral law reports, where the Supreme Court succinctly reviewed cited cases on interpretation of the Constitution and outlined these principles, guiding principles as follows. A, in interpreting the Constitution, which is the supreme law of the land, mere technical rules of interpretation of statutes will be avoided so as not to defeat the principles of government enshrined therein. Hence, a broader interpretation should be preferred unless there is something in the text or in the rest of the Constitution to indicate that a narrower interpretation will best carry out the sub-objects and purpose of the Constitution. B, all sections of the Constitution are to be construed together and not in isolation. C, where the words are clear and unambiguous, a literal interpretation will be applied, just according to words, their plain and grammatical meaning. D, where there is ambiguity in any section, a holistic interpretation would be resorted to in order to arrive at the intention of its framers. E, since the draft person is not known to be extravagant with words or provision, every section should be construed in such a manner as not to render other sections redundant or superfluous. If the words are ambiguous, the lawmaker's intention must be sought first in the Constitution itself, then in the other legislation and contemporary circumstances by resort to the mischief rule. B, the proper approach to the construction of the Constitution should be one of liberalism, and it is improper to construe any of the provisions of the Constitution as to defeat the obvious ends which the Constitution was envisaged to achieve. In the case of Nafiu Rabiu and the state, Bendel State was Attorney General Federation, Buhari, Obasanjo, Savannah Bang, Ajilo, Abia State was AG Federation. In finding appropriate answer to this issue, are we to observe first that, with all due respect to counsel to the petitioners, their interpretation of Section 134, subsection 2B of the Constitution, founded principally on a fixation that the word "and" appearing between the phrases, it has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states of the Federation, the federal capital territory Abuja is completely fallacious, if not outrightly ludicrous. Even their recourse to the case of Abubakar and Yaradua does not help their argument because Toby JSC made it clear that a purposive rule of interpretation will not be appropriate where the intention of the lawmaker is clear, precise, and unequivocal. So much so that a person can say, yes, this is what the lawmaker has in mind. Thus, in the interpretation of the Constitution, the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provision. The Global Excellence Communication Limited, Donald Duke, AG Bendel State, AG Federation, Saraki versus FRN, Sky Bank PLC, Yugu, Kelim versus Gwabang. That this is the position is not at all open to doubt. In Bronic Motors Limited versus Wema Bank Limited, Nnamani JSC or blessed memory, speaking from the Apostle Court, confirmed it when, after a painstaking analysis of the cases on the point, said at pages 30 to 32 that, quote, a constitution is a living document, not just a statute, providing a framework for the governance of a country, not only for now, but for generations yet unborn. In construing it, undue regard must not be paid to merely technical rules. Otherwise, the objects of its provisions, as well as the intention of the framers of the Constitution, will be frustrated. As stated in Minister of Home Affairs versus Fisher, the constitutional requirement should not necessarily be construed in a manner according to rules which apply to acts of parliament. Although the manner of interpretation of constitutional instrument should give effect to the language used, recognition should also be given to the character and origins of the instrument. Such an instrument should be treated as sui generis, calling for principle of interpretation of its own, suitable to its character, without necessary acceptance of all the presumptions that are relevant to legislation of private law. It has also been accepted by all our courts that a broad and liberal interpretation should prevail in interpreting the provisions of our Constitution, although one has constantly to bear in mind the object which such provisions were intended to serve. Udo Udoma, JSC, very aptly stated this in Nafiu Rabiu and the State, where the learned justice said, my lords, it is my view that the approach of this court to the construction of the Constitution be, and so it has been, one of liberalism, probably a variation of the theme of the general maxim, ut res magis valeat quam periat. I do not conceive it to be the duty of this court to construe any of the provisions of the Constitution as to defeat the obvious ends the Constitution was designed to serve, where another construction, equally in accordance with the words and sense of such provisions, will serve to enforce, to protect such laws of court. Some years down the line, in Global Excellence Communications Limited versus Donald Duke, Onogian JSC, later CJ, reiterated the relevant principle of the implementation of the Constitution, which his Lordship saying, among others, at page 19. Followed. The principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the scope and purpose of its provisions. The words of the Constitution are therefore not to be read with stultifying narrowness. Close of quote. All these were further followed by this court recently, the Federal Republic of Nigeria versus Muhammadu Maigari Dingyadi, in the following ways, at the 33 of the report. One main guiding post is that the principles upon which the Constitution was established, rather than the direct operation or literal meaning of the words used, measure the purpose and scope of its provisions. See global excellence communication, other cases. There is always a need for the fulfillment of the object and true intent of the Constitution. Therefore, the Constitution must always be construed in such a way that it protects what it sets out to protect and guide what it's meant to guide. The Adeleke or your State House of Assembly. In interpreting the Constitution of a nation, it is the duty of the court to ensure the words of the Constitution preserve the intendment of the Constitution. Every Constitution has a life and moving spirit within it, and it is this spirit that forms the reason of the Constitution, without which the Constitution will be a dead piece of document. The life and moving spirit of the Constitution of this country is captured in the preamble. It has been held that when a constitutional provision is interpreted, the cardinal principle is to look to the preamble to the Constitution as guiding star, and the directive principles of state policy as the book of interpretation. And that while the preamble embodies the hopes and aspirations of the people, the direct principles set out the proximate grounds in the governance of the country. Takur and Union of India. In other words, in interpreting the words of Section 212(1)A of the 1999 Constitution as amended, the court should be guided by principles upon which the Constitution was established, rather than by direct operation or literal meaning of the words used in the provision. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned to another approach that accords with the guiding principles of the Constitution. The interpretation that would serve the interests of the Constitution and best carries out its objects, purpose must always be part. Close of court. Following these well-settled principles, our first port of call in unlocking the argument of the petitioners is the preamble to the 1999 Constitution and the direct principles of state policy contained therein, all of which embody the principles of the Constitution. The preamble to the 1999 Constitution loudly proclaims equality between citizens as its cornerstone, among others. Thus, we, the people of the Federal Republic of Nigeria, having firmly and solemnly resolved and to provide a constitution for the purpose of promoting the good government and welfare of all persons in our country on the principles of freedom, equality, and justice, and for the purpose of consolidating the unity of our people. Do hereby make and give to ourselves the following Constitution. For those who are not used to reading preambles, the Constitution, still in its fundamental objectives and directive principles of state policy, contained in Chapter 2 of the Constitution, which this court aptly described as the road to construction in Federal Republic of Nigeria, and Dingyadi repeats this equality principle. Under its social objectives provision of that chapter in Section 17 thereof, it again proclaims that 1. The state social order is founded on ideals of freedom, equality, and justice. 2. In furtherance of the social order, every citizen shall have equality of rights, obligations, and opportunities before the law. Equality of rights in every citizen, as stated in this provision, cannot by any means be read to exclude equality of the weight and value of their vote. No, it includes it. Even more so, when the issue here is the right of every such citizen to elect with their votes their president, whose policies are supposed to and will affect all of them, equally regardless of which part of the country they reside or live. So even stopping here, the futility and hollowness in the argument of the petitioners that the votes of the voters in the FCT, Abuja, have more weight than other voters in the country, to the extent of their votes purportedly have a veto effect on other votes, is rendered bare. That notwithstanding, let us still proceed to consider, for whatever it is worth, their interpretation of Section 134, subsection 2B of the same 1999 Constitution, which incidentally centers around the word "and" that provision. In the first place, the settled position of the law is that in interpreting a constitutional provision of the court should be guided by the principles upon which the Constitution was established, rather than by the direct operation or literal meaning of the words used in the provision. And where the literal meaning of the words used are not in consonance with the guiding principles, literal interpretation must be jettisoned for another approach that accords with the guiding principles of the Constitution. It is quite clear that a calm reading of Section 134(2)(b) of the Constitution will leave no one in doubt that the use of the word "and" by the framework between the words all states in the Federation and the Federal Capital Territory Abuja indicates nothing more than that the framers understandable desire for consistency in referring to the Federal Capital Territory by that name, as it is done all through the Constitution whenever reference is made to the Federal Capital Territory. The word and Federal Capital Territory Abuja do not by any means imply the meaning imputed to it by the petitioners. In any event, Section 299 of the Constitution dispels any lingering doubt that may still be existing in anyone's mind by stating that the provisions of this Constitution shall apply to the Federal Capital Territory Abuja as if it were one of the states of the Federation, then ABC. This provision states most unequivocally that the entire provisions of the Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. It is noteworthy that the punctuation mark employed by the framers immediately after the part of that provision ending with Federation, emphasized by me, is a semicolon, whose function is in a sentence is to separate independent clauses of a compound sentence. See Merriam-Webster's online dictionary, which defines semicolon as a punctuation mark used chiefly in a coordinating function between major sentence elements, such as independent clauses of a compound sentence. Wikipedia also explains its use thus. In the English language, a semicolon is most commonly used to link two independent clauses that are closely related in thought, such as when restating the preceding idea with a different expression. The point being made here is that, contrary to the position of the petitioners, by the express provisions of Section 299 above, the provisions of the entire Constitution shall apply to the Federal Capital Territory as if it were one of the states of the Federation. This means that Section 134, Subsection 2B of the same Constitution, requiring a president candidate to poll at least 1/4 of the votes cast in 2/3 of the states of the Federation in order to be returned elected, means nothing more than that the Federal Capital Territory shall be taken into account in calculating the state 2/3 of states of the Federation. In other words, the FCT is no more than one of the states of the Federation for the purpose of that calculation. Nothing more than that can be implied or inferable from Section 134, subsection 2B of the Constitution. If anything, this position is confirmed in the cases of Bakari and Ogundipe, where it was said by the Apex Court that by virtue of the provision of Section 299 of the Constitution, it is clear that the Federal Capital of Nigeria has the same status of a state. It is as if it is one of the states of the Federation. And in Ibori versus Uboru, where it was confirmed by this court that the Federal Capital Territory Abuja is to be treated like a state by virtue of Section 299 of the Constitution. If the Federal Capital Territory Abuja is to be treated like any other state, then it is not superior to or inferior to any other state in Nigeria. It is also my considered view that if the framers had wanted to make scoring 1/4 of votes cast in the Federal Capital Territory, Abuja, a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly spread the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. As expressly stated in Section 299 of the Constitution, for the purposes of fulfilling the requirements of Section 134, subsection 2B of the Constitution, for return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of these in the calculation of 2/3 of the states of federation. Thus, that if the candidate falls 25% or 1/4 of votes in 2/3 of 37 states of the federation, FCT Abuja inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to score 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent. In conclusion, I hold without any equivocation that in a presidential election, polling 1/4 or 25% of total votes cast in the Federal Capital Territory is not a separate precondition for a candidate to be deemed as duly elected under Section 134 of the Constitution. In consequence, issue 4 is also resolved against the petitioners and in favor of the respondents. It is right, Lord, that there is a rebuttable presumption of regularity with respect to election results, and it is for a petitioner who challenges that result to rebut that presumption with credible evidence. This settled principle was stated by the Supreme Court in Buhari and Anik, and Nyesom and Peter cite others. Also in Udom Gabriel Emmanuel versus Umana Okon Umana and others. All citations are right. I have also referred to Abubakar and Eradua, Louis versus Anik, Kiriko Duluma Hop versus Barrister Joseph Ella and others. From the foregoing, it is clearly evident that the petitioners have failed to discharge the burden of proof placed on them by law. They have failed to prove any of the 3 grounds contained in paragraph 20 of this petition. They have not been able to lead any cogent, credible, and acceptable evidence to rebut the legal presumption of correctness of the result of presidential election held on 25th February 2023, led by the first respondent. Having resolved all issues, 4 issues in this petition against the petitioners, this petition is clearly unmeritorious. As I stated earlier, it's a consolidated petition. So when we examine that of petition number 4, our learned brothers state their own position. And number 5, sorry.
My Lord, sir, I'm very sorry again, sir.
Yes.
Even if your lordships are going to say, your brethren are going to say their piece later on, sir, at least your own, my Lord, well, you all should be arrested by saying it is either dismissed or is allowed. Huh? I was wondering if your lordship would not pronounce that it's been dismissed. So that...
what are you saying?
I'm sorry, but I don't want to be confused, sir. I've listened to your lordship's eloquent judgment.
Sorry, please, Leonard Senior. You don't have to interrupt judgment. We are delivering judgment and we are still on. Please leave the judgment where it is.
My Lord, I'm very sorry, sir.
If you are confused, when you get the judgment, you read it.
No, my Lord, I'm not confused at all.
Okay, then please.
I'm making a suggestion.
You don't have to suggest to us how to deliver judgment.
I'm sorry.
So you seriously think that all 5 of us wouldn't know that?
Lord,
wouldn't know what we want to do?
I apologize.
Better we proceed. Well, we now proceed on petition number 5. The motions in that petition will be read by my learned brother, by my extreme right.
This is an election petition by the two petitioners against the first, second, and third respondents. The first petitioner, Abubakar Atiku, was a candidate at the presidential election held in Nigeria on the 25th day of February 2023. He was sponsored by the second petitioner, People's Democratic Party. The first respondent, INEC, was established as one of the executive bodies created in Section 135 of the Constitution of the Federal Republic of Nigeria, 1999, with power to, among others, organize, undertake, and supervise all elections to the offices of the President and Vice President and others. On Saturday, the 25th of February 2023, the first respondent conducted election to the office of the President and the Vice President for the Federal Republic of Nigeria and the National Assembly simultaneously. Petitioners and the second, third respondents, along with 16 others, participated in the election. At the conclusion of the election, the first respondent declared the results, by which it is indicated as follows. We show the results for out of the two contestants here we are concerned with. The APC of Tinubu Bola Ahmed and Tinubu Bola Ahmed scored were declared to have polled 8,794,726 votes, and Atiku and the PDP 6,984,520 votes. Petitioners were aggrieved by the outcome of the election, so they filed jointly this petition to challenge this election. The grounds of the petition were 4, and these were stated as follows. 1, that the election of second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. The election of the second respondent is invalid by reason of corrupt practices. The second respondent was not duly elected by a majority of lawful votes. The second respondent was at the time of the election not qualified to contest the election. The petitioners are seeking the following reliefs: that it may be determined that second respondent was not duly elected by the majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent as the winner of the presidential election of the 25th of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. B, that it may be determined that the return of second respondent was by the first respondent was wrongful, unlawful, undue, null and void, having not satisfied the requirements of the Electoral Act and the Constitution of the Federal Republic of Nigeria, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of the states in the Federation, and they put the "and" in capital letters, and the Federal Capital Territory, Abuja. See, that it may be determined that the second respondent was at the time of the election not qualified to contest the said election. See, that it may be determined that the first petitioner having scored the majority of lawful votes cast at the presidential election of Saturday, 25th February, be returned as the winner of the said election and be sworn in as duly elected president of the Federal Republic of Nigeria. In the alternative, another directing the first respondent to conduct a second election runoff, in brackets, between the first petitioner and second respondent. In the further alternative, that the election to the office of the President of Nigeria held on 25th February be nullified and a fresh election rerun be ordered. G, any such further others as the Honorable Court may deem fit to make in the interest of justice. Upon being served the petition, the respondents joined issues with it by filing the respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. We now proceed to consider them. 7 applications were filed and argued by the respondents during the pre-hearing session of this petition. 2 each of the said applications were filed by the first and second respondents, while 3 were filed by second respondent. First respondents' 2 applications were filed on the 19th of April this year and the 9th of May The first of his two applications dated and filed on the 19th, which also largely reflect the position of second respondent in his first two applications and third respondent in his first application. First respondent sought an order striking out paragraphs 92. We gave the paragraphs of the petition on the grounds of their vagueness. Several paragraphs which you get there as you get your the judgment, for being generic, imprecise, and lacking in specificity to elicit a reply from it. B, an order striking out paragraphs 129 and 138 of the petition for failure to join necessary parties. Among other grounds, the two necessary parties are Yaya Bello and one Adevo, the chairman of a local government in Kogi State. 3, another striking out the ground of the petition that second respondent did not score majority of lawful votes as contained in paragraph 16C of the petition for incompetence and lacking in specificity and materials in the pleading for a sustenance. Consequent upon 1 to 3 above, another striking out paragraphs A and B and D are sought in paragraph 150 of the petition, and another striking out the ground of the petition that the election is invalid by reason of non-compliance. Consequent upon 5 above, another striking out the ground of the petition alleging that the election of the second respondent is invalid by reason of corrupt practices as contained in paragraph 16B of the petition for lacking specificity and material facts in the pleading for a sustenance. 7, another striking out the ground of the petition that the second respondent was at the time of the petition not qualified to contest the election as contained in paragraph 16A of the petition for lacking specificity. 8, another striking out the ground of the petition that the second respondent was at the time of the election not qualified to contest the election. 9, consequent upon 1 to 8 above, another striking out and dismissing the petition for being incompetent, frivolous, vexatious, abusive. In the alternative to the above, another striking out paragraphs prayers A, B, C, and D of the petition are sought in paragraph 150 for being incongruous, contradictory, and self-defeatist. The grounds of the petition were stated there, and we set them out, which you get. Second respondent also filed a similar preliminary objection, application for a preliminary objection, seeking striking out of the petition or portions of it. A single prayer on the application is an order of the court striking out jointly and or severally paragraphs 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on this part in his first application on the same issue filed, we gave the date, sought similar prayers like first and second respondents. All 3 respondents also had issues with the replies petitioners served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues with petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so have no place in the reply. For these same reasons, they sought striking out with additional statements, witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following 4 grounds. The entire petition constitutes a gross abuse of the process of court by reason of an originating summons in suit number SDCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by the second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation, where the said plaintiffs raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit polling unit results from his BVAS to his result viewing portal IREV in the 25th February 2023 general elections. The plaintiffs in first respondent mentioned sought in their suit declarations that the 2023 elections were fundamentally flawed and so invalid, null and of no effect, which is what petitioners also seek here. So this petition constitutes gross abuse of process. There were other grounds for that application, as I shall show later when considering it. All 7 applications were supported with affidavits and written submissions of applicants, which were in turn countered by the petitioners with counter affidavits and written submissions of their own. I shall now proceed to consider the merits of the applications. For ease of reference, I shall group the 3 sets of applications into groups A, B, and C. I start with the first 3 applications of respondents that attacked the validity of the petition and all its paragraph reliefs claimed and grounds on which it was sought. First respondent's first application, that is the one filed on 9th of April. I start with that one. First respondent set out the following issues for determination in his 9th April 2023 application. Set them out. It argues its issues 1 and 3, you get it, so there's no point arguing it, time is going. It argues its issues 1 and 2 above separately and took issues 3 and 4 together. In seeking the striking out of paragraphs 9, 2, 3, 93, all set out there, of the petition on grounds of their vagueness, imprecision, and lack of specificity to elicit a reply from it, first respondent, that is INEC, relied principally on paragraph 4.1, sub 1 of the first schedule to the electoral act, which states as follows, says, an election petition under the act shall state clearly the facts of the election petition and the grounds on which petition is based, and the relief sought by the petitioner. Relying on Ugu and Ararume and the number of cases all set out there, Council on First Respondents have argued that paragraph 4.1, said paragraph 4.1 of the first schedule of the electoral act implies compulsion and makes it mandatory for petitioners to plead the facts of their petition. They submitted that an election petition that is vague, imprecise, omnibus, nebulous, or generic is contrary to the provisions of paragraph 4.1d of the electoral act and so liable to be struck out. Net Council then carefully took on each of the said paragraphs and advanced reasons why they are vague, generic as a complaint. Council also argued that the petitioners in paragraphs 129 and 130 of their petition made allegations of unlawful acts allegedly carried out by one Honorable Friday Adejo, Governor Yaya Bello of Kogi State, and some unnamed persons in the course of the presidential election. Yet those persons were not joined to the petition, so those 2 paragraphs are also liable to be struck out. Council cited Bambe and Adetunji, Olori Ode versus Oyebi, and Babatola and Alade Jono to say the court lacked jurisdiction to enter judgment or make orders against persons that are not before it. Responding to the first limb of first respondents' contention that the said paragraphs of the petition are vague and imprecise, the senior counsel to the petitioners argued that the said paragraphs were pleaded in support of the second ground of the petition, alleging that the presidential election was bedeviled by corrupt practices. Prime among those practices, they said, are suppression of votes, manipulation of beavers' machines, and destruction of electoral materials and ballot boxes. Specific instances of these corrupt practices that took place in various states and local governments, they argued, were laid bare in the petition with particulars of the allegation. They argued that first respondent, instead of considering the paragraphs of the petition holistically, seems to have considered them in isolation and apparently hence its wrong conclusion that the petition was vague, imprecise, and without necessary further particulars. While admitting that the names of polling units were not specifically stated in the petition, Petitioners' Counsel submitted that petitioners stated in different paragraphs of the petition that the polling units affected were to be contained in the statistician's report to be relied upon at the hearing of the petition. They cited the cases of Oluwedu vs. Ajayi, Awolaja, and others, as was Citrate, and East Horizon Gas Limited versus Afiok and others. Submit that petitioners have by that pleading incorporated by reference the said statistician's reports. On the argument of the first respondent that the petition did not disclose any reasonable cause of action and so constituted abuse of process, Petitioners' Counsel argued that first respondent was by that argument trivializing matters of high constitutional importance raised by petitioners in the petition. Submitted that a petition that touches on correct interpretation of section 133(2)b of the Constitution of this country, vis-a-vis the return of second respondent and the qualification or disqualification of second respondent, regulated solely by sections 131 and 137 of the Constitution, cannot by any means said to disclose no reasonable cause of action. On first respondent's contention that petitioners' failure to join Honorable Adejo and Governor Yaya Bello and unnamed thugs against whom they made allegations of criminal misconduct in paragraphs 129 and 133 of their petition made those paragraphs of the petition incompetent and liable to be struck out. Counsel to the petitioner submitted that section 132 of the Electoral Act has specified the persons who may be joined as petitioners or respondents in an election petition. That Honorable Friday Adejo and Governor Yaya Bello having not participated in the election or returned, petitioners are not in violation of the Electoral Act or any rule of law in not joining them. Besides, they also argued, no relief was claimed against the said 2 men, so they cannot be said to be affected in any way by the eventual outcome of the petition. Now, this is the way we resolve this. My Lord, resolve this. Now, paragraph 4.1 of the first schedule of the Electoral Act, as amended, states thus: 2020 states thus: an election petition under this act shall d state clearly the facts of the petition, and the ground or grounds on which the petition is based and relief sought by the petition. This provision is so clear and direct that it does not require any aid in its interpretation. It simply restates in mandatory terms the first rule of pleading that claimants, in this case a petitioner, shall state clearly, quote and unquote, the facts of the election petition, end quote again, and the ground or grounds on which the petition or claim is brought. This requirement / duty to plead one's complaints and facts clearly in the statement of claim / petition, not reply, is a basic rule of pleading even in ordinary civil proceedings. Emeka in GSC, Natonda versus Ajani, put that point across most forcefully when he said that, and I quote, he said, "It appears to me that rule which required every fact, upon which a party intends to rely at the hearing of the hearing to be pleaded, goes to the fundamentals of justice. For no one and defend the unknown. If one has to defend or counter a fact made by his adversary, the one must have due notice of that fact to enable him prepare for his defense. That is the very essence of pleading. As it goes to the very root of the rule of audi alteram partem, one of the twin pillars of justice, it would be misconception to describe it as mere technicality or regularity. It's a matter which cannot be waived. Indeed, by a long line of decided cases, it has been long settled that any evidence on the fact that ought to have been pleaded but is not, goes to no issue at all at the trial and ought to be disregarded, end quote. Now, the complaint of first respondent is that the petitioners in their petition did not state their case as clearly as required by Section 41D of the Electoral Act, 2002. It complains that petitioners' complaints were vague, imprecise, and lacking in particulars. It does not appear to me that this complaint can by any means be waved away as idle. If anything, even the petitioners seem to have admitted that they did not plead those necessary facts. But their response to that contention, as shown earlier, is that they pleaded a statistician's report, which contains the required details of the polling units where the corrupt practices they alleged took place. Incidentally, the said report, a very voluminous four-part document, the later tendered through his maker, Mr. Samuel Oduton, PW1, during the trial, shows on his face that it did not even exist at the time they filed their petition, and so was not served on respondents along with the petition to enable them exercise their constitutionally guaranteed right of responding fairly to the corrupt practices, quote and unquote, alleged particularized in it, and if necessary, also engage their own expert to reply to it. Engage their own expert to reply to it. Yes, the principle of incorporation by reference relied on by them, that is petitioners, is part of our adjectival law and is supported by a fairly long line of cases, including MMA versus NMA, Ekpemupolo versus Edremoda and others, JFS Investment versus Brawalai Limited, Elo versus Idaosa, Abode Brothers Limited versus Niger Construction Company Limited, and another. But that principle cannot by any means override the fair hearing trial provisions of Section 36 of the 1999 Constitution of this Constitution, which also underpins the rationale for exchange of pleadings by parties. See once again the dictum of Emeka and Atonda and Ajani already quoted. A statistician's report that is supposed to contain missing particulars in a petition, but which was only filed in the middle of hearing of the same petition, long after the time for exchange of pleadings had closed and even after petitioners had called as many as 16 witnesses in proof of their case, as happened in this case, cannot serve that purpose of audi alteram partem, let the other party also be heard too. In short, the tactics employed by the petitioners in this case as regards their pleadings, and the petitioners and the statistician's report referred in it, is to say the least most unfair and definitely negates the current practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statistician's report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent, but it shall only be as they stand in the petition. In that regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State is lacking in particulars of the particular polling units affected and so liable to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think, sufficiently meets the requirements of paragraph 41D of the first schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units in some local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is in my opinion bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondents allegedly depleted and inflated respectively. The need to plead the exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the first schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims a seat alleging that he had the highest number of valid votes cast at the election, that is which is what the petitioners are doing here, the party defending the election or return shall set out clearly in its reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed. Second and third respondents can only properly exercise their right under this provision, requiring them to, quote, give particulars of the votes claimed by the petitioners that they object to and the reasons for the objection against such votes, after petitioners have themselves set out clearly the lawful votes depleted by the manipulation alleged by them. Paragraph 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as the petitioners have stated in those two paragraphs that the disruption of elections in Adavi and OKE local government areas of Kogi State by agents of second and third respondents alleged hearing was captured in video recording, which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. It is therefore also liable to be struck out. I'm also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof, which is a matter for the substantive hearing, especially as the infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election materials, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and what these failures enabled the results of the polling units in the said LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as to the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly says so, my lord. We have already produced all these things in EA03, and we don't intend to read. In any case, you get it and you see it. Here also PDP versus INEC. For the same reasons, I am also of the opinion that paragraph 103 of the petition, where the petitioner simply avowed generally that, quote, first respondent wrongly entered incorrect results for the petitioners in Borno State, is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am, however, of the view that paragraphs 104, 105, and 106 of the petition sufficiently plead necessary for us to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent of the use of beaver elections. The presidential election in Benue State, while paragraphs 105 and 106 simply stated the petitioner's ground that second respondent was not elected by majority of lawful votes. In respect of paragraph 104 of the petition, first respondent complains that the petitioners contended that the entire results of the presidential election were wrong, yet they did not plead the results they perceive to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1 of the first schedule of the Electoral Act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of Section 134B of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they have that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondent, so I shall overlook it, at least for now. Petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units failed to properly fill and countersign alterations in election forms, including forms EC, 8B, and blah, 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 but they did not mention the polling units. What local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report, pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondents, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also deserves to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled is well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, he did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 132 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Court petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Wankwo and Yaradua, where Muntaka Kumasi GSC, after reproducing the provisions of the then newly enacted Section 1441, sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, that unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is an issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out. And the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eita Yojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent, APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State didn't talk to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also barred for non-tender. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria Post Party scored the majority of lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also barred and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook section 134 sub 4 of the 1999 Constitution, stating expressly that, and I quote, for the purposes of an election to the office of president, the whole of the federation shall be regarded as one constituency, end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the federation or even the federal capital territory only become of consequence when the issue verges on whether the candidate returned also satisfy the provisions of section 131B and 2 of 1999 Constitution, as amended, requiring him to poll 25% of votes as in a list two-thirds of the 36 states and the federal capital territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition, the person returned as the winner of the election. See further on this, the cases of Buhari and another versus Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others, particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, an unsuccessful candidate in an election cannot be made a party to an election petition against his will, end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. But I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 143 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results for 22 name states therein, paragraph 44, where they averred that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where this said, quote and unquote, large scale discrepancies took place. And paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front load, are barred and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said. It's also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. that paragraph of the petition falls far short of the requirements of paragraph 4.1b of the First Schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused the petition of committing electoral malpractices, paragraphs 92, 95, 98, 11, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 4.1b. They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140. On the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether having regard to the mandatory provisions of paragraph 4.1b of the First Schedule of the Electoral Act, the reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraph 16a, b, C, and D of the petition to warrant further or any adjudication on same. Counsel on behalf of first respondent this time anchored the arguments principally on the grounds on which petitioners founded their petition. Counsel reproduced paragraph 16a, b, and C of the petition where the petitioners alleged, we read them out. The next reference, section 134 of the Electoral Act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135.1. So the fact that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the Act, if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and the non-compliance would have substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, Senate Counsel submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complaint of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. That not only the petitioners not assert in their petition that the non-compliance complaint of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court form an opinion on that non-compliance and corrupt practice complaint of substantially affected result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioners counsel submitted have simply blown quote unquote muted trumpet and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners have vowed that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election. In that, the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. Answer to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition as by reason of the alleged submission in the petition identified above had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction to entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issues 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. For this application, letter counsel second respondent simply said that the sole issue for determination thus was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant Electoral Act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, and 108 of the petition are not liable to be struck out. We we set out the arguments, both of them. He said, in the course of determining first respondents' application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. Same exercise, I also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitioners, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we this thing, and said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 147 of the petition omitted by the first respondent in the application, determined the complaints of second respondent of whether petitioners' complaints in those paragraphs were vague, imprecise, and generic. I now start that exercise. Without prejudice to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the averments in the petition, I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the we do not also find paragraphs 20 to 20 of the petition where the petitioners complained that first respondent did not keep to his earlier promise of electronic transmission of election results to its IREF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4(1)d and 15 of the first schedule of the Electoral Act 2022, the averments in paragraph 22 of the petition, where the petitioners complain the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 27 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters cards collected the unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first respondent, first petitioner, and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in the conduct of the election, which practices they complained took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondent's votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akwa and Port Harcourt local areas of Rivers State did not reflect the actual votes. If not express the SL votes, actual votes scored in the said local government areas, or even those updated to IREF by INEC and so liable to be voided, no correct quote unquote figures of the actual votes cast as reflected in the IREF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. Sum total of the foregoing are complaints of vagueness, imprecision, and genericness of averments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of petition are deemed in order and pass the vagueness test of paragraph 4(1)d of the first schedule of the Electoral Act. Pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by legal counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty of second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka GSC while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution to Wankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of trial tribunal in that case that paragraph 12 sub 5 of the first schedule to the Electoral Act, same as paragraph 12(5) of the present Electoral Act, okay, permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Wankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defy it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Wankwo and Yaradua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. Our own application, that is the third respondent this time. That in his own application of 8 May, third respondent, like the first and second respondents, also paid us to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogo State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' amendments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election. Petitioners argue in response that their complaints were properly pleaded in the petition and so not imprecise, nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents relates to the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. Further hold that petitioners have amendments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house expert from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners, what is here? In petitioners, the amendments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses, testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and respondents succeed only partly, and the following orders are made on them. Paragraph 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out. as prayed. The remaining paragraphs of the petition attacked past the vagueness test and paragraph 41D of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent also filed on 8th of May 2023, as well as the three applications of third respondents, all objecting to the petitioner's replies to their petition, to their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, then we went on to say that the thrust of the response of petitioner's counsel, that is 455. Thrust of the petitioner's counsel is a suit number SCV 351 that was not filed by the petitioners. So this petition, sorry, I'm still reading 544. That now it is certain position of the law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See your Okafor vs. Attorney General of Anambra State. Necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Alhaji Atiku Abubakar, and his political party, the PDP, can be properly described as previous of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response for the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is recent new currency case. The new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case, the said suit number SCCV 354, 2023, filed by the plaintiffs in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. Just simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. Proper sanction in circumstances of this case, as we have already pointed out, citing Nwankwo and Yaradua, to strike out the paragraphs of the petition where those allegations were made. That order we also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutiga and Pastor Chalon on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. Okay. So the next one, we now go to the challenges the replies filed with the petitioners. All three respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner, and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They are sought striking out of paragraphs 1.1, 2.1, 2.3, and 2.1 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the production as Senator Dino Melaye, and PDPC, both deposed on 20th April, striking out the petitioner's list of additional documents dated 20th day of April, which accompanied it. Sorry. Thrust of the argument, which is counsel founded principally, and we replied, we reproduced the arguments, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. The second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be had to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court, to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in Temple of Justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. That obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of petitioners, therefore rejected. Coming now to the merits of the application, it is common ground that the provisions of the Electoral Act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. Cited cases, I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this thing, only restates the well-settled position of adjective law that a claimant's claim or grievance are made in his statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Olubodu and Lawal. Cited what the Supreme Court said there. They said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad, and no evidence would be admissible in his proof, end quote. In fact, that settled position of law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied. This is cited. As to what will amount to a new issue, we cite again a Gesimba versus Nuzurike, earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners to their reply. The additional environment not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61A of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 21B of their reply that they were simply given, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they averred in paragraph 1B of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)B and C of the reply, where petitioners aver to no uploading of polling unit results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues or at least mere further denials by the petitioners, respondent denials of the petition. Such is not also permitted in the reply. See again, Bakar and another, versus Ibrahim, Akeredolu versus Akinremi, Egesimba versus Nuzurike, Spasco versus Alrain, Ishola versus LGB, and Obot versus CBN. In the light of all the foregoing, the two witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in the issue, are also incompetent and liable to be struck out. In summary, first respondent's applications of 9th May succeeds in its entirety. Accordingly, paragraphs 1, 2, stated them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)B, 2.1B, C, and D of the petitioner's reply, filed in response to the reply of first respondent together with the two witness statements or note and list of documents which accompany that reply are all hereby struck out. Second respondent's application seeking striking out the self-respondents. Learned counsel, he also made his arguments, and then we come straight to the resolution. And I said here, my Lord said here, that I'm not even in the least persuaded by the argument of the petitioners, that they simply reply to new issues raised by second respondents in reply to their petition. Petitioners, like they did in their reply to the reply of first respondent, introduce fresh and issues of non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1A to the first schedule of the Electoral Act expressly forbids. Consequently, paragraphs 1B, 1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. Second respondent, where the petitioners about new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24B of the petition we hold on the state of the authorities earlier considered are also new facts or at best mere denials and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, now we come to the third respondent's application. And we come straight to say that I find necessary to first observe that, like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist qualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 15A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, bar last paragraph 35, are, as third respondent's counsel rightly pointed out, either mere denials of third respondent's reply to the petition or repetitions of petitioners' averments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act. See again, cited cases. It's also not the law, as erroneously argued by petitioner's counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. Somehow, counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. Here, Gesimba's case, Ayola GSC, I cited the summary third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians who want to call it, so that my Lord can continue from there.
We'll go to the respondent's objections to documents tendered at the trial. My learned brother, by my immediate right, read the ruling.
Thank you. We want to take on the respondent's objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the 3 respondents. First, to the validity of the witness statements on oath, proposed to by some of the witnesses of the petition. Specifically, EW12, that is petitioner's 12th witness, Eguma Friday. PW13, that is Grace Timothy. PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obasa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohamed Haruna. PW21, Mr. Samuel Odunta, a statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulus Ado. PW25, Victoria Sani. PW26, Hitler Egwonu Nwala, a forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties. The ruling on it deferred by the court to final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1, the validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, that did not accompany the petition as required by paragraph 45E of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents Council on 8th of June 2023, when PW12 Mr. Eguma Omachono Friday, the presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition, and even after hearing of the petition had commenced, Respondents' Council again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanikwekwe SAN, for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned Counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6 sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondents has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Nwala, but also their last witness, Mike Enaoroeba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Nwala, and Mike Enaoroeba, have already been found incompetent and struck out by this court while ruling on the applications like preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or notes were not front-loaded with the petition are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus. Now I want to mention it. It says the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANDP, versus INEC and two others, appeal number EPT 406/2020, and People's Democratic Party versus Okogbo, citation supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 45B of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party NPA versus INEC, in appeal already cited, presided over by Justice Igenimpa and Agim, her colleagues, as Agim as he then was unanimous in his decision on the point in issue. JCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 34554 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call in proof of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath to witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoena witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi Ararume and INEC, this court also decided over by my Lord Justice Samani JCA, the concurrence of my brothers Owade Kimbami, Bolaji Yusuf, and Bayero JCA, again confirmed this position when in that decision was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena at cificandum, but it must be realized that this witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement or note was subject to the requirements of the law as stipulated by paragraph 4.5 of the first schedule. Strict compliance with paragraph 4.5 of the first schedule to the Electoral Act is mandatory. It's of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okagwe, and then Ogba and Vincent, Midra and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have their citation here, and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midra versus Patricia Ete and another, and Lasso versus Aweyemi, relied on strongly by Mr. Chris Uche, SAN, what the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche, SAN, the lead counsel for petitioners hearing, wrote a glowing forward to. The learned author, Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SI position of this court in Omirira and Nete, and then Lasso versus Aweyemi. There, Chief Uche, SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidirong versus Sete, see also Lasso and Aweyemi, citation supplied, wherein the Court of Appeal held that it would be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held, I think that this court in Omidira and Nete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidiron's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing a petition and closure of pleadings, paragraph 1 of Election Tribunal and Court Practice Direction 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal and court practice directions as overriding the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics, we have earlier mentioned it in 03. As earlier said, Chief Chris Uche SAN in his forward to that book glowingly endorsed this author's position and even recommended it to judges like us in these words. The author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019 permitting parties to file witness deposition of a subpoena witness even after commencement of their action applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement is said of their witnesses filed by them after hearing of the petition had long commenced wherein were in order, full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioners' Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act. Unquote. What all that means is that where there is express provision in the Act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the Electoral Act 2022, that says the election petition shall be accompanied by written statements on oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in the court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh, may not meet the justice of the case, as is being suggested by the petitioners, that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that a witness on subpoena should also depose to a witness statement before the subpoena before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords of Lords ordaining MRL in Dupont Steels Limited versus SIRS, citation supplied, where the learned Lord Scammon in his speech said, "But in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. Interpretation does, of course, imply in the interpreter a power of choice where different constructions is possible. But our law requires that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Palatable statute may not be disregarded or rejected merely because it's unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits its idea of what justice requires in any case." That is a settled position of the law, even in this country. See Ndomaegba and Shukwogo, citation supplied. Aromolara versus Aguru. Coca-Cola Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new Section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management through pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okobu, and others, citation supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties and open the floodgates for all kinds of abuses of the judicial process. Quote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC. And then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor, Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuagu GSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16 Ms. Edosa Obosa, PW17 Ms. Aleria Ayuba, PW18 Ms. Sadia Mohamed Aruna, PW21 Mr. Samuel Odunta, the statistician, PW23 Janet Nuhu Turaki, PW24 Christopher Bulusado, PW25 Victoria Sani, PW26 Hitler Ewonu Nwala, forensic expert, and PW27 Mr. Mike Enaroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioners' witnesses, namely, as I already listed, EW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INE, which documents parties had agreed at the pre-hearing session that they will not object to. So respondents cannot resile from that agreement and raise objection as they are doing. They even cited section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As counsel, as ministers in the Temple of Justice are therefore within their right and in fact duty bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Answer to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of June 2023. Second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under section 104 of the Evidence Act 2011 for certification of public documents. They said petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, PAJ to PAJ 37, PAJ 38, PAJ 39A to F, PAJ 40, PAJ 41 to PAJ and PAJ 41 to PAJ 7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Then I cancel all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argued that certification fees for the said documents having not been paid by the petitioners, documents remaining admissible and liable to be expunged from the records. Petitioners in response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that there were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Then Senior Counsel on petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that section 104(1) and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification fees were not paid for is clearly erroneous. Now, Section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it, as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document. As required by subsection 2, payment of certification fees is only a condition precedent to the certification. So it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoman, Sodike, ANPP, and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made by the receipt number RRR 270-842-653235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face thus the sum of 6,696,301 naira 25 kobo only being payment for CTC IPO electronic of a copy of data level number data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election unquote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent, INEC, to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that it did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 1041 of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the said documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168(1) of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal recites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, It was also argued by the respondents relying on Belguri and Ahmed that certification of the same documents was done by public officer of INEC by engravement of his name, official title, and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the said documents and verified that unlike Belguri and Ahmed, the documents in issue here bear the longhand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argued that exhibits PAH1, PAH2, PAH3, and PAH4 tendered by PW21 Mr. Samuel Odunta and exhibit PAR-A to F tendered by PW26 Mr. Hitler A1 Nwala were made during pendency of this proceeding or in anticipation of it, and therefore inadmissible in evidence by virtue of Section 83.3 of the Evidence Act 2011. In their response, the petitioners argued that the said documents were made pursuant to the orders of this court, pursuant to Section 146.1 of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling, that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition, are incompetent and so already struck out. I'm also of the opinion that the petitioners seem to 595 seem to completely misconceive the objection raised by the respondents, which is to the effect that the said documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011, and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to Section 146 of 1 of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, Section 146.1 of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of Section 83, sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows the petitioner to file evidence, let alone the bulky expert reports, as in exhibits PAH1 to 4, PAH1AF, PAR1A to F, during the pendency of the petition. The whole idea behind Section 83.3 of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was to produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH1 to 4 and PAR1 A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the said reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, PAH4 and PAR1A, PAR1B, C, D, and E and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of Section 83, sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then the next one is inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential irrelevance to the petition. The respondents' argument here are given. So we'll now skip that to the resolution. We've seen that, and the resolution we have is, it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and its agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Oshun, Taraba states. Pleadings, they said, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done as it should be done, the respondents would have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results as purportedly declared by first respondent in respect of each state of the federation, including the Federal Capital Territory, the details of which are contained in the table below. The table was given are wrong. Then they proceeded to list each of every state of the federation. They also gave in the table wrong election figures declared by INEC for each state and FCT. Then in paragraph 147 of the same petition, they listed 60 different types of sets of documents they intended relying on to prove the said averment. In paragraph 107 of the wrongness of the result declared by INEC for each state and the FCT, the presidential election. Among those documents listed by them are BVAS CTC reports, B, forms EC8 series, then EC8A, EC8B, EC8C, EC8D, EC8DA, EC8E, that's certificate of return received by petitioners' agents at the election. C, summary of the total registered voters on units basis. D, summary of PVCs collected on unit basis. E, data and event logs from all BVA's machines used in the election. And F, PVC collation records. These documents were specifically listed at paragraphs 147.1, then 6, 36, 37, 56, and 57 of the petition. These are the same averments to documents respondents are asserting were not pleaded by the petitioners and so irrelevant and inadmissible in evidence. They are indeed wrong. This ambit of the objection of respondents is therefore overruled and rejected. Then objection made by only the third respondent. The next set of objections to documents tendered by the petitioners were raised by only third respondent. I now proceed to consider them. Admissibility of video clips. Arguments were advanced there on, okay. Okay. Yes. So we said, I'm of the opinion that the contention is also misconceived, especially when regard is had to paragraphs 1, A, B, E, F, G of the certificate of authentication of the said video clips made by PW19 Dr. Ter. The authentication required by Section 84 of the Evidence Act in the circumstances the video clips in issue were made is statements assuring the court that they are in exact same state they were in the internet from where Dr. Te, PW19, downloaded them to his laptop computer and subsequently to his flash drives before bringing them to this court. That much is evident in the contents of Dr. Te's certificate in Exhibit PAF 4B above. For the same reason, the argument of Dr. Te is not in, the argument that Dr. Te is not in position to answer questions on the said clips, and so his evidence on them is hearsay, is also non sequitur. Then there is also the issue of dumping of documents on court as ground for admissibility. With this one. Okay, that's part of the issue which will be considered deeply. Okay, you see, that is it. This is, okay. Some of them are listed. The simple and straightforward answer to this argument is that the issue of dumping of documents on court, which expression in any case suggests that the documents so dumped are already in evidence before the court, only goes to the weight to be attached to the documents by the court. On this reasoning, this ground of the objection is rejected and overruled. Then also there is allegation that some documents tendered were either made during pendency of this proceeding, I think I've seen that, and anticipation of it by interested parties. I think we've done a little consideration of this earlier. So we'll go to number 3. They said also that exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, and up to PBF4, tendered by the petitioners through PW27, Mike Enauro, to show second respondent's non-qualification for the presidential election on grounds of his alleged conviction stroke fine in the United States of America, forgery of certificates and dual citizenships are irrelevant to the proceeding and so inadmissible in evidence, petitioners having not pleaded necessary facts in their petition to support them. This also was looked at by us, and okay, and I have already ruled while considering the preliminary objection of the respondents to the petition and replies of the petitioners that paragraph 146 of the petition, where the petitioners averred to non-qualification of second respondent for 2023 presidential election, was bereft of facts to sustain it. I also held that the fresh facts of second respondent's conviction / fine by a district court in Illinois in United States, alleged forgery of documents and dual citizenship, all of which petitioners only introduced for the first time in their replies, were incompetent. They ran foul of both paragraphs 4.1d and paragraph 16.1b are incompetent, liable to be struck out, and were indeed struck out. I'm also aware that we have just a few seconds ago ruled here in this judgment that evidence of PW27, though through whom they say the documents SB now impeached by third respondent were brought in, is incompetent for non-compliance with paragraph 4.5b of the first schedule to the Electoral Act. Those rulings constitute issue estupel, binding not only on the parties but on this court too, meaning further that this court cannot depart from them. See Francis Shano and Afri Bank, and also Lawal Daodo and Cardoso and Daniel and all that. Consequently, the objection of third respondent to the admissibility of this evidence earlier highlighted, the objection is hereby upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Summary of all the foregoing is that 1, the objection to the evidence adduced by PW12 witness Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajabona. Okay. Well, we said all those ones we have mentioned and also recouched here, we say that the objection is upheld, and that evidence together with the documents, reports included, tendered by the same witnesses are hereby expunged from the records of this court. Secondly, the objection of respondents to exhibits PAH1, PAH2, PAH3, PAH4 made by Mr. Samuel Odunton, PW21, and exhibits PAR1A to F made by Mr. Hitler Wanwala, PW26, is also further upheld, and the said documents already held incompetent and inadmissible by our earlier rulings are again hereby pronounced inadmissible in evidence on this ground too. Then the third one now, exhibits, or the objection of third respondent to the admissibility of exhibits PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD2A, PBD3, PBD4, PBE1, up to PBF3, PBF4, tendered by PW27, Mr. Mike Enauroeba, is also upheld, and the said documents are further ruled inadmissible and expunged from the records of this court. Save for these ones mentioned above, all other objections of the respondents to documents tendered by the petitioners are overruled. Well, at this level, I hand over, like my brother said, to my leader to continue with the judgment. Thank you.
Well, I now consider the substantive matter, the substantive petition. I however wish to state that despite our conclusions above on the objections raised by respondents to documents tendered by the petitioners, I am still mandated to evaluate evidence adduced and consider merits of the petition. The only evidence I shall not revisit are exhibits PBD, PBD1A, PBD1C, 1B, 1C, 1D, 1 PBD1A, PBD2A, PBD3, PBD4, PBE1, 2, 3, 4, 5, 6, PBF1, 2, 3, 4, and 4, relating to second respondent alleged non-qualification that were tendered by PW7 at 27. Mr. Mike Enauroeba, the said documents in our view, being bereft of pleadings to sustain them as a liberal stated earlier in this judgment. Coming to the hearing, the petitioners called a total of 27 witnesses and closed their case on 24th June 2023. The respondents opened their respective defenses starting from 3rd day of July 2023. The said respondent called one witness as one of its staff, RW1, and closed his case. The second respondent also tendered documents and called one witness, RW2. The third respondent did not call any witness but tendered documentary evidence. At the close of the case of the parties, the court ordered written addresses. The addresses were filed on schedule. In the final address for the first respondent filed on 14 July 2023, the learned leading senior counsel of first respondent, Mr. A.B. Mahmoud SN, raised 4 issues as follows. 1, whether having regard to section 47, subsection 2 and 3 of the Electoral Act 2022, paragraphs 38 and 92 of the regulations and guidelines for the conduct of elections 2022, and totality of evidence adduced at the trial, the inability of the first respondent to transmit the polling unit results electronically in real time using the BVAS device to the RF portal constitutes non-compliance with the Electoral Act if such substantially affected the outcome of the presidential election held on 25th day of February 2023. 2, whether there exists cogent and credible evidence of corrupt practice to warrant the nullification of the presidential election held on 25th day of February 2023. 3, whether going by the provisions of section 131 and 137 of the Constitution of the Federal Republic of Nigeria as amended, the second respondent was at the time of the presidential election held on 26th day of February 2023 not qualified to contest the said election. 4, whether upon proper construction of section 134(2)(b of the Constitution of the Federal Republic of Nigeria 1999, the requirement that a candidate must score not less than 1/4 of the votes cast at the election in each of at least 2/3 of all states in the Federation as the Federal Capital Territory, Abuja, means that a successful candidate must specifically score at least 1/4 of the votes cast in the Federal Capital Territory, Abuja, in addition to 2/3 of all the states. The second respondent, through his counsel, Wale Olanipekun, SAN, filed his written address on 14 July 2023. He raised for determination 4 issues which were listed as follows. 1. Considering the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, the salient provisions of the Electoral Act 2022, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and/or provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the peculiar circumstances of this petition, wherein the petitioners pleaded no fact in support of their allegation of non-qualification of the second respondent, whether the second respondent was or is not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of Section 134 and 299, as well as other relevant provisions of the Constitution, Section 66 of the Electoral Act 2022, and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitution of the petition and the task evidence adduced, whether this honorable court can accede to any of the reliefs being claimed by the petitioner. The third respondent, through her lead counsel, filed its final address on 14 June 2023. Similarly, 4 issues were generated for determination. 1. Whether, having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th day of February 2023 was vitiated by non-compliance and corrupt practices that was substantial enough to direct or directly attributed to the second respondent as to have affected the outcome of the election and to justify notification of the election in a manner envisaged by the applicable provisions of the Electoral Act 2022. 2. Whether the burden of proving that first petitioner and not second respondent scored majority of lawful votes cast and satisfied the constitutional requirement of having 1/4 of the votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioner. 3. Whether, having regard to the issues joined and evidence led on the qualification of the second respondent to contest in the presidential election held on 25th February 2023, the petitioner has established that second respondent was not qualified to contest the presidential election as provided for in the Constitution and the Federal Republic of Nigeria 1999 as altered. And 4. Whether, having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the reliefs sought in the petition at all, or that the petition ought to be dismissed in favor of the respondents. In response to the addresses filed by the first, second, and third respondents, the petitioners, through their leading counsel, Chief Chris Uche, SAN, filed their respective written addresses on 21st July, 22nd July, and 23rd July 2023. The petitioner's senior counsel filed separate written addresses in response to each of the first, second, and third respondent addresses. The issue for determination raised in the 3 written addresses filed by petitioners in response to each of the written addresses of each of the respondents are the same, and they are: 1. Whether the return of the second respondent in the election to the office of the President of the Federal Republic of Nigeria held on 25th day of February 2023 was not invalidated by reason of substantial non-compliance with the provisions of the Electoral Act 2022 on electronic transmission of results for collection and verification. 2, whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja, as required by the Constitution of the Federal Republic of Nigeria, 1999, as amended. 3, whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from that related offense, his acquisition of the citizenship of a country other than Nigeria, and presenting a forged certificate to the first respondent. 4, whether the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of the lawful votes cast in the election. A look at the issues formulated by the parties will show clearly that, though differently worded, they are similar in context and content. It is in the face of this that we choose the 4 issues formulated by the petitioners, albeit with necessary modifications to anchor the determination of this petition. The issues for determinations as modified are as follows. 1, whether the return of the second respondent in the election to the office of President of the Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. 2, whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, having not secured 1/4 of the valid votes cast in the Federal Capital Territory, Abuja. 3, whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria as amended to contest the presidential election held on 25th day of February 2023, having regard to the alleged order of forfeiture arising from the drug-related offense, his acquisition of the citizen of the country other than Nigeria, and presenting a forged certificate to the first respondent. 4, whether the second respondent was duly elected by majority of the lawful votes cast in the election and the first respondent was right in returning him as duly elected. So we go to issue number 1, which is whether the return of the second respondent in the election to the office of President of the Federal Republic of Nigeria held on 25th day of February 2023 was invalid by reason of substantial non-compliance with the provisions of the Electoral Act 2022. Yes, we have considered the submissions of counsel, which we have summarized here. So we'll just go straight to the resolution of that issue. This issue of non-compliance is directly standing on the first ground of this petition. Thus, by paragraph 16A of the petitioner stated that the election of the second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. By section 1341B of the Electoral, non-compliance with the Act is a ground for questioning or challenging an election. Primarily, the law is well settled that the results declared by any first respondent in an election enjoy a presumption of legality. In other words, they are prima facie correct. Section 168 of the Evidence Act 2011 recently applied by the Supreme Court in Atuma and INEC and APC. Were in JSC held as follows. By virtue of Section 168, sub 1 of the Evidence Act 2011, presumption of regularity in universe in favor of judicial or official acts, including those carried out by INEC. The exact words of the subsection are thus: when any judicial or official act is shown to have been done in a manner substantially regular, it is presumed that formal requisites for its validity were complied with. Fortunately for the appellant and first respondent, it is only a presumption which implies that it is rebuttable. Any person who questions the validity of an act in favor of which there is a presumption of regularity has a duty to rebut the presumption with cogent and credible evidence. A flimsy or half-hearted rebuttal will not suffice. Loss of court. Any petitioner who complains that the result as declared is either wrong or not in compliance with the Electoral Act has the onus of proving the contrary. See Newsom Peter side. This case was relied upon by the Supreme Court in the case of Andrew and another versus INEC, where the Supreme Court, per Onogen JSC, held as follows. Well, the term is far gone, which keep those petitions. When you get the judgment, you will see. Generally, it is the law that he who alleges must offer the requisite proof. The petitioners have the burden of proof, and they must succeed on the strength of their case as per their pleadings. The level of proof required is twofold. The first level is that there is non-compliance. The second level is to prove that the non-compliance substantially affected the result of the election. The learned senior counsel for the petitioners had in this petition argued that the burden of proof is on the person asserting the positive and not on the person asserting the negative. The petitioners, it appears from their position, tend to cross the line of misconception as to who has the burden of proof in adversarial system of justice in civil cases when the primary onus of proof is on the petitioner who makes all the claims against the respondent in this case. Well, we had started this case of Dache and Bruven by Ugo JCA in the earlier petition just determined. That's petition number 3. Usually the burden of proof is the debt owed by the petitioners to the success of their petition. The burden of proof rests upon the party who substantially asserts the affirmative of the issue. It is fixed at the beginning of the trial by the state of the pleadings. If the party with the burden fails or could not discharge the burden, the decision must be against him. The case of Adegoke and Adibi Supra, relied upon by the petitioners, was cited in the recent case of Folarin and Augusto, where the Supreme Court by Okoro JSC held as follows. The quotation is there. It is therefore settled that the terms negative and affirmative are relative and not absolute. The burden of first proving existence or non-existence of an assertion or fact, whether positive or negative, lies on the party against whom judgment will be given if no evidence were produced on either side. In the instant case, it is fundamental to point out that from the pleadings, the allegation of non-compliance is generated by the petitioners. Under Section 1341 and 135 of the Electoral Act, the level of proof required for the success of the petition is doubled. There must be proof of non-compliance and the further proof that the non-compliance affected substantially the result of the election. In the face of such an allegation of non-compliance, the court is enjoined by the law not to invalidate an election if it appears that the election was conducted substantially in accordance with the principles of the Electoral Act. All said and done, the petitioners have the primary burden of proving that there was non-compliance and that the non-compliance affects substantially the result of the election before the burden can shift to the respondents to establish that there was no substantial non-compliance with the Electoral Act in the conduct of the election. If petitioners have in their petition pleaded some of the facts relating to their complaint of non-compliance to the Electoral Act 2022. The key paragraphs of their petition in that regard are paragraphs 18, 22, 23, 25, 28, 29, 35, 36, 37, 38, 39, 40 to 44, 46, and 48 of the petition. The respondents joined issues with the petitioners in respect of this issue, and they all denied the facts pleaded by the petitioners. The denials of the first respondent in its reply are very significant. In paragraphs 17, 18, 19, 31, 32, 33, 34, 35, 36, and 37 of the first respondent reply to the petition, the first respondent is in great measure denied all the allegations of the petition. In the petition, since those paragraphs are direct and straight denial by the first respondent, the burden of proof remains on the petitioners to establish their claim as required by the law. Apart from the first respondent, who is the primary respondent, due to the fact that it is its acts that are challenged in this petition, the second and third respondents, who are the beneficiaries of the declaration of the results, join issues with the petitioners. The second respondent, in its reply to the petition, countered all the petitioners pleaded in respect of the this issue. Issue 1 with paragraph 6, 33, 56, and 57 thereof. The third respondent countered the petitioner's allegations with paragraph 26, 37, and 40 of his reply to the petition. Non-compliance in ordinary parlance means failure to or refusal to do something that you are officially or statutorily supposed to do. See Shulua and another versus To J.I. 13, Ojuku and Yaradua and Akeredulu and Mimiko. The Electoral Act 2022, in an explicit manner, has laid out clearly grounds upon which an election can be questioned in Section 134 thereof. Then there is Section 135 of the Electoral Act, which looks like it provides to Section 134 for proper appreciation of the intendment of the law. Section 134 and 135 of the Electoral Act must be considered together. Well, an election may be, 1341 says, an election may be questioned on any of the following grounds. B of it says the election was invalid by reason of corrupt practices or non-compliance with the provisions of this act. Then 135(1) says an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this act if it appears to the election tribunal or court that the election was conducted substantially in accordance with the principles of this act and that the non-compliance did not affect substantially the result of the election. This ground of non-compliance to the Electoral Act has been in all our electoral laws, even from when we had parliamentary system of government. The courts have over the years shed a lot of light on the requirement of the law in proving the allegation of non-compliance. A short chronicle of the decisions of our courts will throw more light on the evidential burden of proving non-compliance. For that purpose, we cited the cases of Bassi and Young, Awolowo and Shagari. We also cited the cases of Buhari and Anada versus Obasanjo and others, and CPC versus Buhari and others. So in all these decisions, the evidential burden of proof of non-compliance lies on the petitioner, who must first prove that there was non-compliance, and secondly, that the non-compliance has substantially affected the results being contested. Let me say that at the risk of sounding repetitive, that it is after the onus on the petitioner is discharged to the satisfaction of the court, that the onus will shift to the respondents to establish that the results were not affected. It follows, therefore, from the authorities referred to, that for the petitioner to succeed in the allegation of non-compliance, they must plead clearly in their petition the non-compliance and call witnesses or place before the court cogent and credible evidence of such non-compliance. The petitioners need to place before this court evidence based on their pleadings, indicating that the non-compliance has affected the votes cast at the election and that the impact is substantial enough to invalidate the election. The petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the National Collation Center. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicates of results from EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraphs 7, 8, and 11 of his statement, he deposed that from his analysis, he discovered various forms of non-compliance and corrupt practice such as suppression of votes, manipulation of beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of multiple printing at the polling units. In PDP and ANEC and others, this court, per Agim Jesse as it then was, held that it is only a polling unit agent, or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in the unit. See also Goyol and Anada versus ANEC, Buhari and ANEC and others. In the instant case, PW1 was not a polling agent, he was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling unit agents in all the polling units and that they are still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. His name is Dr. Solarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW 3, 4, 5, 6, 7, 8, 9, 10, 11, and 11 are all collation agents. The evidence of these witnesses centered around the events and the duties carried out by the polling unit agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units. Under our law, specifically in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or her principal. Having regard to the fact that no mortal can be in all the places at the same time, the law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by the law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows therefore that PW 1, 2, 3, 4, 5, 6, 7, up to 11, PW 19, 20, and 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election of the ward, local government, and state and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. This court and the Supreme Court in several cases have explained the intent of this legislation. But that started JAM and OG, UTE and the state, CASA and the state, UKUD and the state, Buhari and Obasanjo. It is therefore settled law that hearsay evidence is not admissible to prove a fact of non-compliance with the Act. It follows that the evidence of the collection agents in this case, instant case, who are PWs 1, 2, 3, 5, and 7, relating to the suppression of votes, multiple tampering of ballot papers, entering of wrong scores, results, disruption of voting, are inadmissible hearsay and are hereby discountenanced. In the instant petition, the petitioners called 27 witnesses and tendered documents and exhibits. The main and crucial complaint of the petitioners from the evidence placed before the court was the inability of the presiding officers employed and used by the first respondent to upload and transmit the polling unit results to the first respondent's result viewing portal, that's IREF, and the electronic collection system. Of the 27 witnesses called by petitioners, 10 of whom were presiding officers who manned some polling units on the election day. A look at their evidence will bring out the facts of how the presidential election was conducted in some of the polling units on 26 February 2023. These witnesses are PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25. PW 12 is Yoguma Omachuku. The witness was on subpoena. He was the presiding officer in Collation Unit 07, Ward 3, Aba North of Abia State. His evidence is that the election was conducted as his polling unit and that at the end of the election, the results were recorded on the result sheet and duplicate copies given to the party agents at the polling unit. He stated that he had challenges in uploading the presidential election results from his polling unit to the IRF portal and electronic collation portal. When cross-examined, the PW12 testified that the election was peaceful and that it was the image of the result on Form EC8A that was supposed to be uploaded to the IRF portal. He further testified that the result sheets were delivered at the Ward Collation Center to the annual Ward Collation Officer. He said he was happy with the conduct of the election. PW13, Grace Timothy, who was the presiding officer for a polling unit in Bauchi State, corroborated the testimony of the PW12. She could not upload the result of the election to the IRF, but that the party agent signed from EC8A and that she took the original result to the Ward Collation Center. PW14, Grace Ajabona, whose petition was polling unit 6, Ward 1, Yaba West, local government area of Kogi State, equally testified that the election result from her unit from EC8A was signed by her and all the party agents before she took the result to the Ward Collation Center. The PW15, Abidemi Joseph, was the presiding officer in charge of polling unit 047, Ward 9, Maji of Babambola community in Maji, Suleja, Niger State. She gave the evidence also that election was conducted in her unit and that the results were signed by her and the party agents before she took it to the Ward Collation Center. She also could not upload the result to the average viewing portal of ANIC. The PW16, Idosa or Bosa, was the presiding officer at polling unit 09, Welu Health Center, Ego Ward 05, Edo State. She equally testified that even though voting went well in the election at her polling unit, she was unable to upload the result of her unit to the RF using the beavers. She did the manual recording of the results into Form EC8A and signed the result along with the party agents. The result was equally taken by her to the Ward Collation Center. The same story was told by the PW17, Alheri Ayuba, who presided at the